I file an IA Miller for extension of the time Miller. That is that may come on Miller with his pleasure Friday Miller.
Friday.
Friday. Miller.
Beg your lordship. My lord, I beg to mention item number 27, my lord.
Yes.
Item number 27, Mr. D. Bhattacharya is appearing. My lord, he has submitted his leave application, my lord. So, madam, kindly list after vacation, my lord.
Sir, these are admission matters.
Yes, madam.
We'll pass necessary order. Okay?
Yes. Obligation.
Yes, yes, sir. Item number 18. Can it be taken up some other day? Today I have some difficulty. Only for 1 day accommodation I seek.
No, these are admission. We'll pass
Okay.
necessary order. No, no.
May I
Right.
please your lordship? Lordship, I beg to mention item 17, which English council is having some personal difficulties.
Okay, let the matter reach, we'll see.
Obliged.
May I please your lordship, I beg to mention item number 33. Item number 33. Kindly the matter may be adjourned for the day. The
Let the
learned.
matter reach, we'll pass the notice.
Your lordship.
Please, your lordship. Lordship, the impugn order, my lord, at page 9, my lord. It's a one-page order, my lord.
Where is the illegality?
my lord.
Where is the illegality?
What was wrong with the order?
My lord, in the order, my lord, there is no order for registration, my lord, of the incumbent.
That is sufficient. You pay for registration. Where is the illegality? Why do you need to be cost? At best, you can pay for registration. And your submission before the in writ petition is that you are not aware of the order.
Yes, my lord.
It is not that you are not aware of the proceeding.
Yes, my lord, I am aware of
You
that.
appeared, you did not file your written statement, time was granted on
Well-
several occasions.
My lord, if your lordship go through the order sheet, my lord, at page 11, my lord, on my lord, page 11, my lord.
Mm.
On 21/12/1987, my lord, opposite party present and filed petition praying time for written statement. Petition allowed, fixed on 24/1/1988, my lord. And my lord, next date, my lord, if you are see, my lord, it's not fixed on 24/1.
Did you appear on 24? Have you filed any?
My lord, I
Let us see.
went there, my lord, I
You
have
could have-
met,
That date was fixed on 24, so I am appeared, but the fixed
yes,
is
my
not
lord,
fixed today.
I have give
Let us see
the,
your Hazira, whether you appear or not.
my lord, I give my statement, my lord. On the given date, my lord, I went there, but they told me that the record is not available, my lord. They could not find the record, my lord.
What record? Your application will be there.
At para, my lord, 2, I have stated, my lord. The petition further said on 24/1/1988, the petitioner went before the learned foreigner tribunal Lakhimpur, but he was sent back by the prescriber of the learned foreigner tribunal Lakhimpur as the record of the case was not traceable. And therefore, my lord, on 25, my lord, my absence was recorded. And my lord, very next day, on 6/2, my lord, I appeared. Opposite party absent petition filed praying for time, my lord. That filing petition also I annex, my lord. At page 6, as page 18, my lord. The opposite party is suffering from fever for last several days, my lord. And thereafter, my lord, only on one date I failed, my lord. No sufficient time has been given, my lord. Only on 33 to 1988, my lord.
1988, what you've been doing?
Well, I am not aware, my lord, that.
How come you are not aware? You are aware of the case. It was pending,
Yes, my lord.
right?
And my lord, police also submitted, the inquiry officer also.
After 6th of February, what you have done?
6 February.
For your lacuna, you cannot blame the tribunal. And what made you to inquire only in the year 2018? After more than 10 years? If a matter that is also, it's not a small matter. You're supposed to be a foreigner.
My lord, the inquiry officer also filed that I am in between, my lord, 66 and 70.
Whatever may be,
Yes.
see, proceeding that is relates to a issue of whether you are a citizen of India or not. The issue is not small or not very simple.
Yes, ma'am.
You did not appear.
Yes, ma'am, that is my.
In spite of knowing you took time, your applications are here before the tribunal in record.
Well, that is on my part, my lord, I failed, my lord, to appear, my lord, at page, my lord, 20, my lord, I have the, my lord, my name is recorded in, my lord, 1971, my lord, voter list also. At page 20, my lord, my name is Satish Mandal, my lord. And subsequently also, I, my lord, cast my vote, my lord.
Yes, Ms. Verma.
After 20 years, Lordship, he's approached this court. 88 order and to 2018 he filed, and all through he was very much aware of the proceedings.
No, he was fully aware. That is why he filed to, but he did not appear, but
And
he filed.
18 is only because of the NRC, I'm sure. But one thing I fail to understand is how he has been casting his vote.
Possible. Election Commission of India is there, state is there, many things is possible. Will you be able to answer one particular thing?
Lordship,
The tribunals are passing order. The courts are passing order, either in favor of the procedure or against the procedure. When will you send him back?
there's nothing to, as such on record,
Then
Lordship.
why are you sitting here?
That is the Lordship. We have taken up this issue number of times, but it's always the lack of political will or whatever.
So what will
Lordship,
happen?
not
Why should
happening.
we declare somebody to be a foreigner if they are not send them back to the appropriate country?
These answers can be given only by the people who's running the state, Lordship. We get very limited instructions to place before this court.
No, basically, you see, anyway,
But Lordship, the conduct of the proceeding is,
here, okay. Well, first simple order. First of all, there is no explanation in approaching this court after 1988.
20 years
Last
now,
application before the tribunal sitting time was of
2008, Lordship.
1988.
Yes.
His last application was
It's
before the tribunal.
33 or-
6/2/1988.
6 2 years, Lordship.
6/2. Thereafter, he did not appear before the tribunal.
I may be allowed to cite, my lord, this judgment of this honorable court, my lord. Motinal, similar matter, my lord. This
Similar,
honorable,
what kind of similar?
my lord, he also, my lord, failed to appear in category of 6671, but this honorable court will allow one time, my lord, for 30 days to register, my lord. Similar.
We'll do the same thing.
One.
Ms. Verma, who will be the FERO here?
In this matter,
This matter is from Lakhimpur.
we'll have to find out. Nowadays, all SPs of the districts, they are the FROs, Lordship, because they even officiate as border SPs. But Lordship, in this matter, it is not 20, it's not 20 years after he's approached this court. This order was passed in 2014 and the reference is of 12. The one which my friend is referring to.
That is also, my lord, some time also elapsed, my lord, in that case also, 4 years. my lord.
Time, Lordship will consider sometime, it cannot be unlimited
Only,
time,
my lord,
Lordship.
My prayer is that, my lord, some time is given so that he can register, my lord.
Lordship, even if that sometime is granted, it would have been 180 days, 2 days back, Lordship had taken up a matter. Once order is given for registration, within that stipulated time, if it is not
No, only thing
registered,
what we found is
Yes,
that in this
Lordship.
particular order impugned in this petition is that the tribunal did not specify for registration. Tribunal determined that he is a foreigner of this
stream,
particular
only the stream has been determined.
But that direction was not there because necessarily direction was not there. The opinion was sought only for whether he is a
Foreigner or not, yes.
now we'll grant him 30 days time.
Yes.
The rule says what? The act says what? Citizenship Act for registration, section 6A.
Lordship, the time has been specified.
That time we gave now. Section 18 is the rule. Now rule frame under section 18(6)(a).
Yes, Lordship, for a person registered, Lordship will subject to the provisions, Lordship, so and so. 4 says.
Come to
Lordship.
section 651(3),
513.
6A3.
Yes, Lordship. A person registered under subsection 3 shall be deemed to be a citizen for all purposes as from the date of expiry. That is only after that 10 years period has expired. 4 would be for my friend Lordship.
Hmm.
4 would be, and there's another where this says it's only 180 days can be granted. I'm just looking into that, Lordship. After a certain period of time, if they have not registered,
Non-receipt of the order of the petition was petition.
Lordship may come to the provisions as to citizenship of India for persons covered by Assam Accord, Lordship.
Section 6A3.
9, I'm reading 19 of the Citizenship Rules 2009, Lordship.
Rule 19.
Rule 19, Rule 19(2), Lordship.
Hmm.
An application for registration under subsection 3 of section 6A shall be made in form 18 by the person to the registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of the order of foreigners tribunal declaring such person as a foreigner, providing that the registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 60 days. 2A says a person who has been declared as a foreigner by the Foreigners Tribunal prior to 16th July 2013 and has not been registered under subsection 3 of section 6A for the reason of non-receipt of order of the Foreigners Tribunal or refusal by the registering authority to register such person as a foreigner on account of delay may be within a period of 30 days from the date of receipt of the order passed by the Foreigners Tribunal, or from the date of publication of this notification, make an application for registration in Form 18 to the registering authority of the district in which such person is ordinarily a resident, provided that the registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 180 days, Lordship.
That is 2A.
That is 2A.
Proviso.
Proviso, Lordship. And Lordship, along with that, 6A, Lordship, at the Citizenship Act 1955, 6A, Rule 3, Lordship, no, Section 3, Section 3, Lordship will come to B, 3. Subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam before 66 and after 66 and before 25th March 97 from the specified territory and has since the date of his entry into Assam been ordinarily resident in Assam, has been detected to be a foreigner, shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority thereafter in the subsection referred as may be specified in such rules, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted thereon. So, Lordship, 2 of these rules and section go with his
See, first
matter.
of all, here, the case of the petitioner is that prior to 2013, he was declared to be a foreigner.
Yes,
This is
Lordship.
under the rules.
Rules,
Right?
yes.
Now, second part is, there is no such requirement for the tribunal to give a direction that he should register or
Register.
she should register if declared to be a foreigner of a particular stream
Stream.
from 1/1/1960 to 24/3/1970. The rule says, once the tribunal declares him to be a foreigner of that particular stream,
Stream.
he himself or she, the proceeding
go and
itself is
register.
required to for registration.
Yes, Lordship.
But there is no direction
No
or there
doubt.
is no such provision in this Citizenship Act or in the Foreigners Tribunal.
Yes, it only says, Lordship, within a period of 30 days from the date of receipt of order of the Foreigners Tribunal.
Right,
Only that much.
that much. So it is the duty of the proceeding to register himself
Yes,
once
Lordship,
been declared to be a foreigner of that particular
that
stream.
particular stream.
Now it has not been done.
And 20 years have
Later,
passed.
he approached this court for
Yes.
this order. Now, what rate should be applied? It is not under statutory.
Yes.
So, what will, who can grant time to the proceeding now approach the authority?
Lordship has the power to
What
do
power?
In
That
urgent
is the
cases
reason we are
also.
asking you. Now, do you have to exercise the power of
that.
mandamus?
Mandamus, Lordship.
Why? We are not here for mandamus.
This is under certiorari.
So, now tell us.
Lordship will take it up as an exceptional matter, Lordship, because Lordship has gone through the rules and the sections.
Authority is available only with the registration office.
Direction now.
Yes, Verma, as per the rules, that power is available only with the registering authority, not with the court.
So Lordship may direct the registering authority to in
Will not
accordance with-
direct, we even to approach the registering authority.
Yes.
Wouldn't speak the time
But,
to,
but he has already written that they have refused. In his synopsis I saw. When did he approach Lordship? That is the question.
that is
If
not
he's-
there.
Yes, he has not put the date
Date is not there.
specifically when he has approached the registering authority. If he is approaching after 20 years, they are also, had their hands also tied, Lordship.
Brother is pointing out correctly that after 180 days, the registering authority
No.
won't do.
That is the reason I took Lordship to 180 days. I was not exactly sure whether there is more time on that or not.
There is. So maximum time that can be
180.
granted by the registering authority is within the period of 180 days.
That's the
30 days.
maximum, yes.
That is the power of the registering
Yes.
authority.
And for 180 days, Justice Bhuiyan had passed lot of orders. I'm talking about Justice Ujjwal Bhuiyan. He had passed lot of orders and
So
he
that
had
was
given
that
time.
period.
Yes, that period, Lordship, but not after 20 years. My specific thing is, he has not given the date when he has approached the registering authority. And will the registering authority take it up after 20 years, Lordship? Or maybe
And
after
in
10
other
years?
Citation is, my lord, also there where, my lord, this honorable court has passed order after 15 years, my lord. My lord, Banu Das, my lord, is there, my lord.
But that will be correct in law.
My lord.
One wrong cannot be
Honor-
correct, Lordship.
It's a single, is my lord, honorable Justice B.K. Sharma, my lord, earlier passed this order, my lord.
But definitely not.
Yes, that-
That would have been available.
Yes, Lordship, it says, however, such time limit can be extended by the registering authority. Justice Sharma's order, paragraph 2. Only under very exceptional circumstances, preventing the applicant from filing the application due to reasons beyond his control. He'll have to go and approach and give his reasons, Lordship. But such
See,
extension of time,
Ms. Verma,
yes, Lordship.
that provision was incorporated in the rules 2009.
180 days.
It came only in the year
2013, by.
16th of July 2013.
Yes, Lordship.
This is after a judgment of the Honorable Court, man.
Now,
His opinion is of 1988, Lordship.
that's what we are saying. One part is okay. Before 2013. Fine.
13, yes.
For those cases, 180 days.
He does not come under that also now. And Lordship, it's written, but such extension of time cannot also be for an indefinite period of time, having regard to the object of the enactment of section 60 of 1955 Act.
My lord, may kindly say 1928.
That we have seen.
Yes,
Ms. Verma had shown us 2009 rules.
yes.
Yes, Lord.
That's what 1928, that proviso is there, 180 days. That has come from 13th of July,
That is,
16th of July 2013.
that will be counted from 16th of July
16th of
2000,
July.
180 days. Those who were passed prior to that month, for that was an
30 days.
this proviso was given that we may apply for this.
No, I think so. Pursuant to the full bench decision of Muslim Mandal, this 16/7/2013 amendment has come. Yes.
Okay. I think it was. Hmm? Hmm? It is applicant section number. First page. itu pun kedua. So, ना हे खान दो सौ नौ 88 और 2013 to सब ले लिया ना ना नहीं I'm filing justice on summary judgment. It is single bench, division bench, that's it is special bench.
Now, do you have the judgment of Lordship Justice Sharma? Please read paragraph 3.
A person who does not register within the time limit fixed or within the time limit that may be extended by the registering authority is liable to be deported from India as he is admittedly a foreigner and he has not acquired the right of a citizen of India as has been acquired by a person of Indian origin who came to Assam from the specified territory prior to 1166 by virtue of the deeming provision in subsection 2 of section 6A of the 1955 Act.
So with regard to the petitioner, he is liable to be deported. He is liable to be deported
Yes, Lordship.
because that power is not there. And here the petitioner has failed to place anything before the court that he had applied for registration.
And the compelling circumstances also, nothing is explained, Lordship. Just annexing
Now, whether
some
in such
voters
cases-
does not entitle him.
That is
to
the
be
reason we are
citizen.
asking in such cases whether such concession can be given to him.
No, Lordship. Lordship, there are judgments which says that having or voted twice or thrice and claiming to be a citizen, that is not admissible, Lordship. Or having our name or the proceedings name in the voters list and being declared a foreigner does not give him the right to be a citizen of India.
So tell us what to do.
My lord, I have also, my lord, explained, my lord, that they have also landed property there, my lord,
Whatever,
my lord.
many
Only-
such foreigners declared by the tribunal or by the high court or by the apex court have landed property.
Only, my lord, earlier also this honorable court has, my lord, pardoned, my lord, and given some time, my lord.
Where is that power? That is, we are asking you, kindly show us that provision. Which provision will be applicable in your case? Approaching this court after 20 years, knowing fully about the proceeding.
Or in that case also, my lord, Banu Das, my lord, in my lord, concluding para, my lord, para 4, my lord. Mr. Ayuddin learned counsel for the petitioner prays for a liberty to the registering authority by the petitioner for registering her name upon showing the reasons for non-registering of all these years. In that view of the matter, this petition is disposed of granting liberty to the petitioner to approach the registering authority for registration of her name in terms of the declaration made by the foreigner tribunal by judgment and dated such and such passed in F10 case number. While considering the case of the petitioner, the registering authority shall take note of the aforesaid observation made by this court in Muslim Mandal.
Read para 2.
As per the full bench decision of this court, reported in 2013 1 GLT 807, the state of Assam Muslim Assas time limit can be extended by the registering authority only under very exceptional circumstances, preventing the applicant from filing the application due to reasons beyond his control, for which the reason have to be recorded by the registering authority.
Then para 111 of the Muslim Mandal.
1956 rules as well as 2009 rules as notice above provided the initial time limit for filing application for registration, that is 1 month, which is extendable by another 60 days by the registering authority. Though there is no time limit prescribed section 6A of the 1955 Act for filing such application, having regard to the purpose for which section 6A of 1955 Act has been enacted, it also cannot be said that the fixation of the time limit for filing of application has no bearing on the purpose sought to be achieved by such enactment. However, such time limit can be extended by the registering authority only under very exceptional circumstances, preventing the applicant from filing the application due to reasons beyond his control, for which the reasons has been recorded by the registering authority. But such extension of time cannot also be for an indefinite period of time, having regard to the object of the enactment of section 6A of the 1955 Act.
So in your case, whether it is indefinite period or for limited period?
My
Tell
lord,
us.
in my case, my lord, the person, my lord, is a, my lord, villager, and he
Wait,
having, my lord,
see,
no, my lord, he
That
has,
doesn't mean
my lord, I have category
who
listed.
sleeps over the matter, you know very well.
Yes, my
that-
lord. Yes, my, that is my lord, there, Lacuna, my lord, but my lord, I am, my lord, praying for only some days, my lord.
Saying
So yes, sir.
Vegetarian ground, you can allow him, but as per law, he is not. As per law, he is not entitled.
He doesn't take accommodation, my lord, out of it.
Which law will be applicable? But his husband, it is his fault, he did not appear. No, he came to know in 2018 about that order. It is not that he was not aware of that proceeding. He did not appear. Because he saw it. Whenever he appeared, he took time to file written statement. This is good to operate, will not be deported. Okay, then what will happen? আজি 20 বছৰৰ পাছত আহিলো, কাইলৈ 25 বছৰ পাছত আহিব, কাইলৈ 30 বছৰ পাছত আহিব। So,
Or my lord, give some time him to appear before the my lord foreigner tribunal, so that he can prove his all the documents, my lord.
that part is already over.
In Motinali case, my lord, that my lord at para 5, my lord, Motinali case, my lord, that by my lord, coordinated my lord division, my lord. At para 5, we have heard the learned counsel for the parties and also take note of the order.
Wait a minute. It is not there. Take a sit, just see one particular decision. হ্যাঁ, করবো, করে যাবো, বিক্রম করবো হয়ে যাবে। না, না, কর্ম Yes, 2 to 9/2014.
এটি মাস এখানে পূর্ব certificate $495 for in appropriate case only, follow different input.
Late for an
Into one to modify. One develop. At the same time, not functioning as people to the internal. Because we are trying to try to I will initially there to be but it's the beyond the কিন্তু ইয়াত কোনো কারণ দেখুন নাই কেউ অ্যাপ্রোচ করার জন্য।
Ms. Verma, just find out if there is any FRRO at Lakhimpur. Just find out.
In some time I will inform you.
Don't you, I will be. He continued to go, the order was of 1988. But he continued to go there.
Amended citizenship, so you can apply. The amendment policy. Okay, we can even apply under the new amended rules, which has been amended now. You can even apply in that also. You can even register it there also.
Will not say anything on that.
That's what I.
SP looking to know.
Yes, it's been working after.
Yes, yeah, for
Not for the, I'm not sure. So it's not about it. Okay. It's fair.
No, because. If I must mind to. No, 1988. No, no, arranges in order to. Registration officer.
District for next question. That part cannot be because it is. Heard Mr. Answer, counsel appearing for the petition. Anyone representing Union of India? No. And Mr. H. Kohli, Standing Council Election Commission India for the responsibility. Also heard MS. Government Standing Council Home Department Assam for the response number 3. Seven and 8. Mr. P. Sharma, additional senior Assam for the response number 5. Mr. Kohli, you will also represent the District Foreign Registration Officer. District Foreign Registration Officer.
Foreigners, it comes under the Home Department.
By you.
Usually represent.
Okay. But is there any district foreigners registration officer or foreigners registration officer? It is FRRO or DFRO?
That part of it. I do not know why he has made it district.
I don't know.
District.
District Foreigners Registration Authority cannot be Tezpur, it has to be Lakhimpur in his case.
I do not know where he has got it from. He can explain that also. Because FRRO offices I know everywhere, but district I have not.
No, district means that particular district.
Yes, sir.
The incident happens at the Lakhimpur district. Instead of approaching the district Lakhimpur, he approached the district Tezpur.
Yes.
Not to take over.
There are some things which are not clear in the petition. He has approached himself. He has not given the date of his when he has applied for the registration. As well as why did he approach Sonitpur? Why not somewhere nearby, Lordship? I was trying to find out the list of FRROs in Assam, Lordship.
Likha. 6. Okay, I don't have to write anybody else. Peruse the record of Furnace Tribunal Lakhimpur, not Lakhimpur, wherein the impugned ex parte final order dated 09/05/1988 was passed by the said tribunal in application case number 859/1987. Arising out of a reference made by the Superintendent of Police Border Lakhimpur. Superintendent of Police Lakhimpur, not Lakhimpur. Don't write both. Whereby the petitioner was declared to be a foreigner who came to Assam after 1966, but before 25/03/1971. And is an ordinary resident in Assam since then. Arguments are hard at length, order reserved.
There is a FRO at Lakhimpur also.
FRR is there in Lakhimpur.
Yes.
Like,
No representation on behalf of the petitioner on call. The name of two counsels have been reflected in the cause list. Register has already received the relevant records from the Fairness Tribunal, 3rd Nagaon. That was called for by order dated 23/07/2018. Next. Petitioner is also in interim protection since 23/07/2018. Notice in this case was issued on 23/07/2018. But it has been wrongly listed for motion. list this matter for admission on 16/7. Fifteen 715. Notice in this case was issued on 25/07/2018. Registry has wrongly listed this matter for motion. The relevant record that was called for by the registry on 25/07/2018 has already been received by the registry. Petitioner is interim protection. SAM 25/07/2018. Should rule, list this matter for hearing on the date to be fixed by the registry. Since the petitioner has been declared to be a foreigner under the Foreigners Act 1946 by the impugn order of the opinion dated 22/05/2018 by the Learned Foreigners Tribunal 8 Palpara in FT case number FT within bracket number 8 bracket close within bracket capital D bracket close 534/2016. She shall appear before the Superintendent of Police Board or Gwalpara on or before 5th of July. Shall obtain bill, give the condition, 5,000, all the conditions. Appear before the Superintendent of Police Board. Same order. Notice was 1/8/2018. Fairness Tribunal 6th Sincere Consult. Since by order, judgment and order the 26/07/2017. Granted Fairness Tribunal 6 also declared the petition to be a foreigner under the Foreigners Act 1946, who had illegally entered from the specified territory of Bangladesh on or after 25/03/1971. She shall appear before the Superintendent of Police Board
Civil search, same date. Place this matter for hearing on 18th of. इसको रूल कर दिया ना, वो रूल कर दिया, नोटिस एंड डिस्कशन कर दिया, शुड हैव बीन पहले जैसा लिखा पहला सेम केस, खाली इसमें लिखना एपीएल तो अलग हो जाएगा, ऑर्डर का भी अलग हो जाएगा, एंड place this matter for hearing on 18th. 5,000 same, everything will be the same.
Lordship has fixed this for hearing on
18th.
18th. Eighteenth of July.
Maybe it's a message.
Same order. Notices may issue water 07/08/2018. That was received from Fairness Tribunal, 5th Dorong Mongol Road. Interim protection 07/08/2018. Rule hearing. Since the petitioner has been declared to be potential citizen by order dated 19/05/2017, passed by the Fairness Tribunal, 5th Dorong Mongol Road. He shall appeal. Same date, same thing. इसमें hearing का date मत देना. Registry shall list the matter for hearing on a date.
Maybe it's a message.
Same order. Notice issued on 09/08/2018. Registry received the relevant records from Fairness Tribunal, 9th Nagaon, Assam. Rule hearing. Interim protection since 9/8/2018. By the interim order is 11/07/2018. Passed by London Fairness Tribunal, 9th Nagaon. The petitioner has been declared to be a foreigner. बस लिखना है, ऐसा लिखना पूरा सब कुछ. Shall appear before Superintendent Police Border, Nagaon, on or before 5th. बाकी condition पर.
Publish.
Some order. This is issued on 21/08/2018. Record receipts from the Fairness Tribunal from Sakala. Interim section 21/08/2018. Rule hearing. As by the impugned opinion of the impugned opinion in order, there are 29/06/2019. The Royal Fairness Tribunal, Baksa, Tamilpur, in FT case number 858/Baksa/2007. when the petitioner to be foreigner. Illegally entered data will be on the specific day on or after 25 January 1971. उसके बाद Salabia, Superinter Police Border Baksa, same date, same amount, same date. बाकी rule और hearing लिखी देना. Sorry, no, this is on 21/0/2008. This is the relevant record on Foreigners Tribunal, Rapida 7. तो पहले लिखना इंटरिम प्रोटेक्शन 21/08/2000. उसके बाद roll carry as by the implement opinion / order dated 13/02/2018. The petitioner has been declared to be a foreigner. The Foreigners Act 1946. Of course, 1971 stream. Yes, I'll appeal will put a the police border on not before same date. Same condition.
Hello.
Instruction awaited.
Yes.
No session. Thank you, sir.
Pursuant to the order is 2905/2024. The Superintendent of Police Udalguri, by his communication dated 13/06/2024, apprised the court about the steps taken by the investigating officer relating to Orang PS case number 43/2024 under section 366 IPC that relates to alleged kidnapping of the minor daughter of the complainant. And you cannot complain, informant. I, the petitioner hearing. The victim is yet to be recovered. Though the police is in search of her as well as the alleged accused, alleged FNM accused. List on 19th July, not 19th July. We make it 24th July. And on the said date, the Superintendent of Police Udalguri shall place the up-to-date status pertaining to the Orang PS case number 43/2024. Fresh. Okay. Copy of the communication dated 13/06/2024 of the SP Udalguri be kept placed before the court today by Mr. P. Sharma, additional Chile Government be kept as a part of the record.
কিন্তু গভর্নমেন্ট এটি একটি নহয় না স্যার মই আছো তো একটি নহয় মই এস্টিমেট একটি নহয়
Yes,
গভর্নমেন্ট
yes.
Yeah, my lord. In this case, my lord, suddenly 25/5/2024 at our police visited the house of the petitioner without registering any case, my lord. And on searching in the my lord PSI court, my lord, in my paragraph in my petition, I stated my lord, on page 6, para 7. There is no case found in the PSI court, my lord. Rather, the police is threatening to arrest the petitioner and visited the house, my lord. Even my lord, police has not received any notice under section 41A, my lord.
Who is the respondent number 6?
Respondent number 6, the private respondent, my lord. At the instance of the private respondent, my lord, police harassing the petitioner. That too without registering any case, my lord.
There is a provision, my lord.
Who is Fariduddin Ahmed?
Yeah.
Who is Fariduddin Ahmed?
Fariduddin, no, my lord. Darazul Ali, son of Fariduddin. Respondent number 6.
There is a provision, my lord, 154(3). That
Police has no power.
that power, if given a writing to SP, my lord. There is a provision, my lord, 154(3) CRPC, file 1. If any refuse to register the case, then file the before SP. But he is not file any complaint before SP, my lord, till today.
150 for information incognizable.
Yes. 154(3), 3.
আমার তো হেতু নয়, আমার হেতু নয়, আমার কথা হল পুলিশ উইদাউট রেজিস্টারিং এনি কেস হ্যারাসিং ইউ।
Then why not file SP before SP any petition?
আমি তো ফটো পাই,
SP action laws.
আমি 220 পেজ আসলে ফটো
SP that very unusual police.
আমি না
153 or something. Which provision?
154(3).
154(3) is the difference.
Not
That's
different.
something different.
It's something
Something
different.
different, but if against that matter is
I'm not on
writing complaint before SP, why
I'm
not
not
file
on
that complaint before SP?
I'm not on that. I'm
No,
on
no,
that matter. Police,
If any police officer,
a police has harassing me without registering any case.
It's not the case.
That's one case. A police may register any case. কোনো কথা নেই।
it is a register,
Register করে না, case করবে।
এখানে তো SP তে বলা যায়।
আমি দিয়া নাই কমপ্লেন গেলে গেছে মোটা রেজিস্টার 154(3) is other difference.
Junior officer against senior officer only বলা যায়। Legal notice তার এগেন্সে দিছে। petition নামিরুদ্দিন আহমেদ legal notice
Legal notice.
notices
Private resident.
SP যদি কমপ্লেন দিয়ে না SP action वाला है मतलब वाला है बुझाई ना SP যদি কমপ্লেন कर दिया है SP को दिया ही नहीं
Heard Mr. A.M. Ahmed, counsel for the petitioner, and Mr. P.N. Sharma.
piece of
Sorry, P. Sharma, additional senior governor Assam, appearing for the split respondents number 1 to 5.
copy दिया
আমি বনাই দেবো এবার
नहीं नहीं
আপনার বনাই দেবো
नहीं no no
মোবাইল করতে ধরেনি
स्क्रीन दिया है कि क्या हो जाए कोई सफा हो पा रहा है नहीं जाए
It appears from this petition, the matter relates to apprehension of the petitioner of being arrested in a complaint or in a complaint lodged by the respondent number 6. But without registering a police case and without issuing any notice under section 41A of the Code of Criminal Procedure Code or Code of Criminal Procedure, or CRPC जो भी लिखना है। It appears from the reading, it appears in perusal of this petition that there is a dispute relating to sale of a particular plot of land. Dispute between the petitioner and the respondent number 6 relating to sale of a particular plot of land. By the petitioner to register sale deed on 01/03/2024. For which he received a legal notice on behalf of the respondent number 6. It is also seen that the petitioner on 04/03/2024 also submitted an affair before the Mongolday police station against the said respondent number 6. List on (26th) June. And I'm bringing the respondent number 4, the Superintendent of Police, Dorong. We apprised the court as to whether any police case has been registered against the petitioner. Before that, let's do that. Petitioner also contended that on 25/05/2024, between 01:00 PM to 01:30 PM, police from Mongolday police station, in his absence, visited his house and inquired about him. However, the said statement of the petitioner made in this petition is as far as knowledge. Then you write placed on such and such, so the rest is such and such.
In the meantime,
That is why I mentioned it for,
not to take any coercive action. my lord.
we cannot do that.
Order copy.
Copy of this order we furnish to Mr. P. Sharma, additional chairman, advocate. Some for his necessary use. Yes, next. Yes, Mr. Alim.
My lord, my claim is that I am a citizen of India by birth. So, first of all, I had to satisfy your lordship regarding the citizenship of my father, my lord. My father's name is not appearing in the voter list prior to 71, my lord. But in the year 66 and 70, my grandfather's name is appearing along with my paternal uncle. And thereafter, my grandfather expired and my father's name is appearing along with my paternal uncle, my lord. So this links myself with my My father is my paternal grandfather, my lord. And regarding my linkage, I have examined my father before the tribunal, my lord.
Take your seat, Mr. Ali. Heard Mr. S. Aslam, counsel appearing for the petition. And I'm S. A. Verma, standing counsel from Department Assam for the response number 2, 3, 2 and 3. Also heard Mr. P. Sharma, additional Sharma Assam for the response number 4. And H. Kuli, Mr. H. Kuli, standing counsel additional information. Dissatisfied with the opinion dated 31/10/2023, passed by Learned Foreigners Tribunal number 2, Kamrup at Boko. In BFT case number BFT, case number 141/2015, arising out of FT case number 02/2008. In a reference being made by the Superintendent of Police, Border Kamrup, Amirgaon. Whereby she has been declared to be a foreigner under the Foreigners Act 1956. The petitioner has filed this petition. On 31/05/2024. Issue rule. Returnable by 6 weeks. Call for the records of BFT case number 141/2015 from the Foreigners Tribunal number 2, Kamrup at Boko. Petitioners have requested extra copies to Mr. such and such for the response number such and such. Petitioners have also served extra copy of this petition to Mr. R.K. Debshidri, Deputy SGI, for the response number 1, obtaining his necessary acknowledgement. Further, the petitioner shall take steps to service of notice on the response number 6 by registered postal GD, providing its correct and proper address, which requisite postal steps. Petitioner shall take such steps of the respondent numbers 1 to 6 on or before 19 June. The date. As by the Interim opinion dated 31/10/2023, the petitioner has been declared to be a foreigner under the Foreigners Act 1946. He shall appear before the Superintendent of Police, Border, Amirgaon, Kamrup, Amirgaon, on or before 5th of July. Back conditions of the biometrics and 5,000. Call for the record.
Highly obliged, madam.
Match figure.
Notice in this case was issued on 14/02/2017. Petitioner is interim protection and interim bail since 14/2017. Registry has also received the relevant records from the Fairness Tribunal, Nagaon, court number 10 at Sankardev Nagar, Hojai. Rule list this for hearing. And it will be fixed by the registry. Petitioner shall appear before the Supreme Police Board of Hojai on or before 5th July for capturing his biometrics. बाकी दोनों का फायदा नहीं.
Obligement.
No legislation. Notice was issued on 27/2/2017. Notice in this case was issued on 27/02/2017. Petitioner is interim protection and interim bail since 27/02. Registry has also received the relevant records from the Fairness Tribunal 7th and Nasiparam. That was called for. Rule hearing shall appear before the Supreme Police Board of Hubli on or before 5th July for capturing his biometrics and something.
Maybe, Lordship. Lordship, my senior Mr. Bcna is absent today due to annual. Matter may be agenda for the day.
Notice in this case was issued on 18/9/2017. The registry already received the relevant records from the Fairness Tribunal number 5 to B. Petitioner interim protection, interim bail since 15/9/2017. Rule hearing, petitioner shall appear before the Supreme Police Board to be on or before 5th July for capturing her biometrics, fingerprints, and something. Notice in this case was issued on 18/9/2017. The registry already received the relevant records from Fairness Tribunal, Nagaon, court number 7 at Lanka, Hojai. Petitioner is interim protection and interim bail since 18/9/2017. Rule hearing shall appear before the Supreme Police Board Hojai on or before 5th July for capturing his biometrics, fingerprints.
Obligement.
Notice in this case was issued on 16/9/2017. Registry already received the relevant records from Fairness Tribunal 5th, Barpeta. Do you have the copy of the petition? Do you have or no?
He doesn't have.
See the cost title of the petition. Petitioner interim protection, interim bail since 16/9/2017. Rule hearing to appear before the Supreme Police Board of Barpeta on or before 5th July for capturing her biometrics and fingerprints. Notice Sudan 21/09/2017. Received from Fairness Tribunal number 1 Nalbari. Interim protection, interim bail 21/9/2017. Rule hearing to appear before the Supreme Police Board of Nalbari on or before 5th July for capturing her biometrics fingerprints. Notice in this case was issued on 22/09/2017. Registry received the relevant records from the Foreigners Tribunal, Jorhat. Petitioner in interim protection and interim bail since 22/09/2017. Rule hearing to appear before the Superintendent of Police Board, 6 Averano before 5th July for capturing his biometrics fingerprints. No representation on behalf of the petitioner, the names of 3 counsels have been reflected in the cause list. Petitioner is interim protection since 22/09/2017. Registry has also received relevant records from the Foreigners Tribunal number 2 Kamrup list on 15th July. Notice in this case was issued on 22/09/2017. Registry received the relevant records from the Foreigners Tribunal. 6. Page 2 at Sutian as the below to you. Petitioner interim protection and interim bail since 22/09/2017. Rule hearing. Petitioner shall appear before the Superintendent of Police Board, Biswanath. On or before 5th July for capturing his biometrics fingerprints. Notice in this case was issued on 22/09/2017. Registry already received the relevant records from the Foreigners Tribunal number 5 February. Petitioner is interim protection and interim bail since 22/09/2017. Rule hearing to appear before the Superintendent of Police Board, February on or before 5th July for capturing his biometrics fingerprints. None appeared for the petitioner on call. No names of 3 counsels have been reflected in the last result. It is seen even the last occasion, on 12/09/2019, the petitioner remained unrepresented. By order dated 12/09/2019, the court observed that notice in this case is issued on 22/09/2017. Registry also received the relevant records from the Foreigners Tribunal number 8 Borpeta that was called for by order dated 20/09/2017. Since 22/09/2017, the petitioner is increasing protection and interim bail. Then you will it is seen that even on last occasion, on 12/09/2019, the petitioner remained unrepresented on court. The court on 12/9/2019 observed that if there is no representation on behalf of the petition on the next date, it would consider to recall that interim protection given to the petitioner by order dated 22/09/2017. Since the petitioner remained unrepresented even on call at the admission stage. The interim protection, interim bail. Don't write. However, considering entire aspect of matter, we like to grant one more chance to the petitioner. List on 16th July.
23.
Notice in this case was issued on 22/09/2017. Registry received the relevant records from the Finance Tribunal, Dima Hasao. Petitioner's interim protection since 22/09/2007. None appeared for the petitioner on call. Though names of 3 councils have been reflected in the cause list. They seen that even on last occasion, I on 12/09/2019, the petitioner remained unrepresented. Based on 16th July.
Lordship may record our presence if nobody is
Look at
appearing.
here. Read the number again. Right. Notice in this case was issued on 30/10/2017. Registry already received the relevant records from the Foreigners Tribunal, Nagaon, court number 10 at Sonkotem Nagar. Petitioner is in interim protection and interim bail since 30/10/2017. Rule hearing shall appear before the Superintendent Police Border Hojai on or before 5th July for capturing of his biometrics and fingerprints.
25.
None appeared for the petitioner on call. No names of 3 councils have been reflected in the cause list. Registry already received the relevant records from the Foreigners Tribunal, Moricam, that was called for. Notice to Lieutenant. Notice in this case was issued on 1/11/2017. Registry received report. Petitioner is interim protection, interim bail since 1/11/2017. List again on 16th.
26.
Notice in this case was issued on 6/11/2017. Registry received the relevant records from the Foreigners Tribunal, Port Valpara. Petitioner is interim protection, interim bail since 6/11/2017. Rule hearing. Petitioner shall appear before the Superintendent Police Border Valpara on or before 5th of July for capturing hard biometrics fingerprints. No representation on behalf of the petitioner. Notice, do names of 2 councils have been reflected in the cause list. Notice in this case was issued on 22/12/2017. Registry already received the relevant records from the Foreigners Tribunal, Bongaigaon number 2. Petitioner is interim protection and interim bail since 22/12/2017. On a reference being held by the Superintendent Police Border, Bongaigaon, in reference FT case number 287 of the 2009. The learned Foreigners Tribunal, Bongaigaon number 2 of Oyapuri. In case number BNZN of FT of 57 of the 2010. By the impugned order, before that impugned order,
After hearing the petitioner, the counsels for the other side, and considering the evidence adduced by the petitioner, declared him to be a foreigner under the Foreigners Act 1946, who had illegally entered the territory of India from the specified territory of Bangladesh on or after 25/03/1971. It is seen that even on last two occasions, I on 06/06/2024, as well as 29/05/2024, the petitioner remained unrepresented on call at the admission stage. Since the petitioner remained unrepresented consecutively on 3 occasions, this state petition stands dismissed for non-prosecution. Pune. Deportation no will pass necessary order will put mention kori gusi gulo. No representation will be called list on 16th. এই বছর দিয়ে ঢুকানো নেই এই বছর দিয়ে সম্পর্কে বড় আপনার জন্য ঠিক আছে list on 16th list on 16th এখনই list on 16th.
Yeah, please.
Notice in this case was issued on 29/01/2018. Registry already received the relevant records from the Foreigners Tribunal, 2nd Nagaon. Petitioner interim protection, interim bail since 29/01/2018. Rule hearing shall appear before the Superintendent of Police Border Nagaon on or before 5th July for capturing her biometrics documents. So the order of notice in this case was issued on 29/01/2018. The registry already received the relevant records from the Foreigners Tribunal number 5th at Gwalpara. Interim protection and interim bail since 29/01/2018. Rule hearing appear before the Superintendent of Police Border Gwalpara for capturing his biometrics and fingerprints. Oh. Notice in this case was issued on 29/01/2018. This to receive the relevant records from the Foreigners Tribunal number 6. Petitioner is interim protection, interim bail since 29/01/2018. Rule hearing shall appear before the Superintendent of Police Border Bongaigaon on or before 5th July for capturing his biometrics and fingerprints. Come back at 2.
July. July.
नहीं ये तो कोई ना खाली रूल इंट्रीम दिस में निकले
July.
आइटम তাৰমানে য'ত নান এপিয়াৰ্ড আছে ন তাতে ৰেচপন্ডেন্ট আমি এপিয়াৰ কৰিছো সেইটো কৰিব যিমান কেছত এইফালে নাই কিন্তু সেইটো দিবা যে ইয়াতে
কি ৰেকৰ্ড আছে লিখি দিয়ক এতিয়া চবে চাব লাগে নটো চাই আছে দহটো চাই আছে
For reasons mentioned in the order, the delay in preferring the connected writ appeal is condoned. The registry is directed to list the connected writ appeal after registration after a week.
Item number 31.
Notice in this case was issued on 21/02/2018. Registry also received the relevant records from the Foreigners Tribunal number 2 Balpura that was called for. Since 21/02/2018, the petitioner is interim protection and interim bail. None appeared on call for the petitioner, though names of 4 councils have been reflected in the purge list on 17th of July. Notice in this case was issued on 28/02/2018. Expired. Do you have? Your good name? MSR, right? No. R. Saha. Full name. Counsel for the, on behalf of Mr. Mukherjee. BJ Mukherjee. On instruction submitted that. Sir, I got it order. Hard mixed non for the petition. Mr. Z. Sharma, Standing Counsel, Home Department, Assam, for the response number 2 and 5. Mr. H. Kuli, Standing Counsel, Election Commission of India, for the response number 3. Mr. H. K. Hazarika, Learned Government Advocate, Assam, for the respondent number 5, 6. Anybody from Union of India? Nobody. Okay. in a police inquiry, being IM within bracket D, bracket close D case number 1756/2004, within bracket লিখিব, during the course of the illegal migration determination of Tribunal Act 1983. The petitioner was found to be suspected a foreigner. Of post March 1971. As such, the Superintendent of Police Border Bongaigaon file number BNGN/B/IMFT/69/06/1750 dated 30/10/2006 referred the case of the petitioner to the by dated number such and such dated 30/10/2006 referred the case to the Foreigners Tribunal Bongaigaon to determine as to whether the petitioner is a foreigner or not. Pursuant to the same, Foreigners Tribunal Bongaigaon Foreigners Tribunal number 1 Bongaigaon in BNGN/FT/ case number 1063/2007. After hearing the petitioner and other parties and considering the evidence adduced by her, by the impugned findings and opinion dated 27/12/2017, opined the petitioner to be a foreigner of post 25, foreigner under the Foreigners Act 1946 of post 25/03/1971 stream. Dissatisfied with the same, the petitioner on 19/02/2018 filed this writ petition. Notice in this case was issued on 28/02/2018 and the record of said BNGN/FT case number 1060/2007 was called for from the Foreigners Tribunal number 1 Bongaigaon. By order dated 28/02/2018, the petitioner was also granted interim protection and interim bail, which is still in force. During deliberation of the matter, Ms. R. Saha, learned counsel, on instruction, learned Saha, appearing on behalf of Mr. B.J. Mukherjee, counsel for the petitioner, on specific instruction from the family of the petitioner, apprised the court that the petitioner Renu Bala Sutradhar, wife of late Kokil Sutradhar, daughter of late Bonu B.A.N.O. Bono Mali Sutradhar, resident of railway quarter number T/23/F,
Railway Old Colony, Police Station and District Bongaigaon, Assam. A resident of resident of Udoy Nagar, UDAY, Nagar, Ward number 25, Bongaigaon. Within bracket MB, Municipal Board Terminal, bracket close, Bongaigaon, Assam. Expired on 30th of May 2019. To that extent, Ms. Saha have placed a copy of the Xerox copy of the death certificate of said Renubala Sutradhar issued by registration number D-2019-19234-0000281 dated 17/06/2019, issued on 18/06/2019 by the registrar within bracket birth and date, Joint Director of Health Services, Bongaigaon. It is seen that after the date of the petitioner, Renubala Sutradhar, on 30/05/2019, till date, none of her legal heir has preferred any application of substitution of their names in place of said petitioner. In place of said petitioner, now deceased. Considering the above, on the date of the writ petitioner, Renubala Sarkar, this writ petition being infructuous stands dismissed. The interim protection and interim bail granted earlier to the petitioner on 28/02/2018 stands merged with this order. The registry shall return the records of BNANFT case number total লিখি said 1062 to the Foreigners Tribunal number 1 Bongaigaon, along with a copy of this order as well as the copy of the death certificate of the petitioner Renubala Sutradhar specified above. Full stop. The copy of the death certificate of the petitioner Renubala Sutradhar placed before the court, dated issued on 18/06/2019 by the registered birth and date Office of the Joint Director Health Services, Bongaigaon, placed before the court by Ms. Saha, learned counsel, on behalf of the petitioner, be kept as a part of the record. On the prayer of the petitioner, list on 18th.
Notice in this case was issued on 01/06/2018. Registry has also received the relevant records from the Fairness Tribunal, number 1 Nalbari. Petitioner interim protection, interim bail since 1/6/2018. Rule hearing to appear before Superintendent Police Border, Nalbari, on or before 5th of July for capturing his biometric fingerprints correctly. Rule hearing লিখেছে তো? Notice in this case was issued on 01/03/2019. Registry also received the relevant records from the Fairness Tribunal number 11 Porpeta. Petitioner interim protection since 01/03/2019. As by the impugned judgment dated 25/09/2018, passed by learned Fairness Tribunal Borpeta 11th in case number within bracket BPT B capital oblique 11 bracket close FT 1456/2017. The petitioner has been declared to be a foreigner under the Foreigners Act 1946. Or post 1971 stream. He shall be released on bail on his appearance for the okay? Superintendent Police Border, Borpeta, on or before 5th July. But condition get a part. Rural hearing correctly. Rural hearing correctly. Pastorate close correctly. Notice in this case was issued. Notice yet to be issued. Oh, notice was issued on 11/03/2019. Registry also received the relevant records from the Fairness Tribunal number 1 Borpeta. Petitioner is interim protection and interim bail. Not on bail, protection. Forget it. No, no. Petitioner shall appear before the Superintendent Police Border. Rule hearing for it. Interim protection 11/03/2019. Rule hearing shall appear before the Superintendent Police Border, Borpeta, on or before 5th for capturing his biometrics. Please. Notice in this case was issued on 08/02/2019. Registry already received the relevant records from the Fairness Tribunal number 1 Dorong at Mongoldoy. Petitioner is interim protection. Interim protection since 08/02/2019. Rule hearing shall appear before the Superintendent Police Board, Border Dorong at Mongoldoy on or 05/07 for capturing his notice in this case was issued on 21/01/2019. Petitioner registry also received the relevant records from the Fairness Tribunal 2nd Morigaon
Since 21/01/2019, the petitioner is in an interim protection. None appeared for the petitioner on call. No name of the counsel has been reflected in the cause list on 18th. Notice in this case was issued on 21/01/2019. Registry also received the relevant records from the Foreigners Tribunal, 6th Borpeta, that was called for. Petitioner is interim protection since 21/01/2019 and interim bail since 24/03/2021. Taken. This rule lists this matter for hearing on a date to be fixed by the registry. Yeah, nalage kyo capturing subase. Registry received the relevant records from the Foreigners Tribunal, 10th Borpeta. Matter pertains to narrative. List on 18th for necessary consideration of the case. 18th. When do you want? 16th, 17th, 16th? Okay. Or 15th? 15th July.
47.
Notice in this case was issued on 17/7/2019. Registry also received the relevant records from the Foreigners Tribunal number 1 Golpara. কিন্তু ঠিক কৰি বলেছিলে হেৰি হ'ব লাগিব মানুহজন ঢুকাইছিল চিলড্ৰেন মাইনৰ 2011 অৰ্ডাৰ দিছে 2018 মাৰ্চত দিছে আৰু মে'ত ঢুকাইছে জেলতে ডিটেনশ্যন কেম্পত এপিয়াৰ কোন হ'ব মানে এপিয়াৰটো ৱাইফ হ'ব নালাগে বাচ্চাকেইটাকো মাকক অলৰেডি ডিক্লেয়াৰ কৰিছে ইণ্ডিয়ান বুলি বাচ্চাকেইটা ৰিপ্ৰেজেণ্টেড কৰে মিষ্টাৰ নন্দী টেক এ seat. মাইনৰ কাৰণে সিহঁতৰ মানে probably they are no more minors because this is the সিহঁততো কৰিব নোৱাৰে unless there is a reference but that tag will be then by tomorrow day after his father can be clear one thing they declared to be in Indian so the children will also become a name they will also be yes Mr. Pine here is a case the proceedee was declared a foreigner in 2011 now proceedee's mother was declared to be an Indian in a similar proceeding but somehow proceedee failed to produce evidence though he submitted his written statement and the order was passed ex parte. He was declared as a foreigner but he was taken into custody in India 2018 in March and he died in the detention camp the same year sometimes in May after his detention the present petitioners came to know about the incident that he was declared as a foreigner so they tried to get us but he was already in custody but as he died during detention and the mother of the deceased the wife of the deceased and two son and daughters children of the deceased filed this writ petition challenging the order of the tribunal now what we have seen there are certain documents and certain statements been made what do you have to say but the mother of the proceedee if you come to page number 61 there is a report that she was declared to be an Indian not a foreigner challenge করবে সেখানে legal aid 2019 application for substitution name place of the petition. Okay. Here is a case where we legal aid or we discuss about so here is the case. So they can challenge the order. Then they can submit their evidence. ইহঁতে কিয় অহা নাই তাতে তাৰমানে link they'll to the link with their father but here is the father expertise order in the sense it was
Written statement was filed probably. But the evidence was not reduced. That's how that's the reason why he was declared to be a foreigner by an ex parte order.
In that case, my lord, now he is no more. He cannot prove those whatever is
But,
there, even though
his
he
legal
remand.
heirs are here.
Yes. So if you, my submission is that, but if it can be remanded back, if they can prove, yes, but whether it will be permissible, because that person,
No, the legal heirs will enter the shoes of the deceased
then
person.
that can be my lord interest. But the personal documents, personal facts, personal things, probably that those cannot be proved.
The documentary evidence will be there.
Yes, my lord. On that basis, if my submission is that it can be remanded back, but only thing is that, my lord, whether it will be permissible for us. Otherwise, there should be another reference.
So what will happen? You see, if the deceased father of the petitioner number
My
3
lord,
and 4,
Well,
there is
well,
no hassles with the petition number 1 and petition number 2. Petition number 2 comes, the link is different. She's
Yes,
the
ma'am.
wife of the
Yes.
deceased proceedee. Now, it will be problem with the two minor children.
minor
The two
children.
and- So they have entered and they are represented by their mother, petition number 2.
My lord, what my submission is that had it been a, my lord, case of full contested case and all the evidences were reduced,
What has happened?
then
The
there could have
petitioner,
been, there were no problem at all.
the
they could
case was
appeal.
dismissed because no documents are placed. Those are not proved.
Yes,
If the present petitioners can prove those documents before the tribunal, there will not be any issue.
that can be, my lord. I have no objection on that. But only the legal question, my question, but the legal aspect, whether that is permissible or not. Had it been, my lord, the documents were proved and all evidences were reduced, and it is only question of law, which were to be decided by the honorable court, then there was no problem at all. But factual aspects, those has to be proved in the tribunal. And those by the children of a dead person, whether it is permissible or not, that is the aspect your lordship may take into consideration. Otherwise, I have no problem, my lord. If it is remanded back, if
I
they
think
can.
there is judgment in this regard. That they can enter in the shoes of the dead person and to prove.
Yes, in that, if it is mother of. Then I have no problem if it is remanded back for that purpose.
It is the same authority. Same authority.
Same
going for
authority.
So.
Not
Same.
it should reference no. But they have to prove that the father was father case.
But the impact is on the children.
Person is like, they are personally, they will go text. More than our text, we have not approved for you.
We are saying. Itself.
मैंने ये जो डॉक्यूमेंट पे कितना फोटो दिए मनोरंजन नंबर पर क्या एक कितना फोटो के नाम मनोरंजन मनोरंजन में नाम की बात it's not all the it's unbelievable. People will around in the region to be to it's correlated it's not all the
Okay, we'll fix this matter on 18th. Okay, we'll see to that.
on the prayer of the council for the parties to install. When Achina hui gol 39 hui gol 40 hui gol This is nothing. Orders ko to ki order sir.
Review petitioners are one hearing matter is there, part heard. So we'll take up these review petitions after the summer vacation. Okay, now we'll take up this hearing matter. Mr. Mahmood will take up these matters after summer vacation. All right. For hearing, item number 45.
The 41, 42, 41, 43, 42, 44 individual order हो गया on the prayer of the council for the party please come to ensuring or on the identity for the university preferably on the hearing day.
Yes, Mr. Sharma.
Yes, ma'am.
My lord, on the last occasion, my lord had asked me that why permit this permanent disconnection. My lord, there are two type of disconnection that is there. One is temporary disconnection, and accordingly, we have given him format 18. And in format 18, we have given him 45 days. And permanent and format 20 is not applicable to him because there is no agreement as such with him. Because format 20, my lord, the format itself says an agreement. And even the clause itself says the initial period of agreement, whichever without prejudice to the right of licensee or of the consumer and for recovery of the any amount due under the agreement.
So according to you, the format 20 for permanent disconnection is not required to be issued to the petitioner because there is no agreement between the FPDCL and the petitioner.
Yes, my lord. When we, my lord, may also take into the effect that in his own legal notice, he has admitted,
That, yes.
yes, he has admitted this. So now, my lord, the learned single judge, while deciding the issue and whatever the issue that has raised, the entire issue started with my lord's order, while where my lord had directed them that you apply for fresh connection and whatever the amount that will be required, that will be outcome of the writ petition. My lord, they have never applied for the fresh connection. My lord, as of today, even we asked them that we are ready to give you a new connection. They don't want a new connection, my lord. They want the same old connection. And my lord, even as of today, my lord, because that old consumer number, that old connection is there, it cannot be placed again because the metering system has also been changed. Now there are smart meter system. So he's only harping on the fact that the notice has not been issued. The notice was being issued, that's by the mail and by fax. Even my lord, the 10.1, the counsel for the petitioners has read it half. A 10.1 C.
In point one, see which page?
My lord, the page. My lord, it will be at page 4011 or 411 or 412. 10.3. Four 14, my lord, may just check. Because if 403 is my lord's the temporary connection starts, then the chapter will be consumer installations and then general provisions. Chapter 10.
Chapter 10, general provisions at 415 in this book.
Yeah, 415. So 10.3, my lord, service of notice. My lord, now there is a C. A notice may also be delivered by any of the following means: fax, email, or SMS by any other electronic mode. So, my lord, this is as a consumer. That is why rightly the learned single judge has held that we are unable to accept the contention of the petitioner in person. An electricity consumer cannot claim that he does not know the billing cycle, and he has a duty to pay the electricity bill timely to have continuous electricity supply. So, my lord, it is awareness upon a person that he should be knowing the fact. And what is the purpose of a notice? There's a notice is a purpose to know that you have see, this is your due, and you have to pay within this much days. And he was aware of the fact. And my lord, neither of his pleading he has pleaded that any of our bills has been wrong. There's nothing on effect to show that any of our bill has been wrong. Every of our bill is correct. He has only been saying that the notice has not been issued. My lord, notice is a part of the electricity bill where, my lord, you enter the consumer number, and being you enter the consumer number and the electricity bill comes, and even the electricity bill is delivered to your home doorsteps. So, my lord, this contention of the petitioner that he was never served with a notice on the 561 cannot be taken, my lord, into account, because there are different modes of knowing about electricity bill. And my lord, after 2 years, he himself has admitted the fact that he knew about the disconnection being done. And thereafter, he did not, when the temporary connection notice was served upon him, and that time also he did not pay the money. It is only after the issue of the PDC bill, he comes and pays the money and says, no, now you have to restore. That the boat has already sailed away, my lord. So the illegality, there is no illegality done by the APDCL, my lord. In fact, that whatever the procedure and whatever the process has to be taken, it has been taken. As my lord, for 2020, this bills are. He paid it in 2022. So my lord may see the 2 years, he does not know that he has to pay the electricity bill. That is why Lord single judge, therefore the statement in the bill under power supply to your premises will be in the consideration opinion of the court would constitute due service of the disconnection notice. The respondent have annexed the temporary disconnection issued the petition on 16/11/2021 under format 18. And now, my lord, he is harping on that the status of the meter is running. That also the single judge says that does not show that that only shows the health of the meter. The clause itself says it's the health of the meter. My lord, with that, my lord, 6.3.5 status of the meter okay, defective, not available. So the status of the meter is running, my lord. So, my lord, even when the writ petition was going on, we have been trying to tell the court that we are ready to give you a new connection. This you have to give us you have to give us the papers, you have to give us, and we will look into it.
This is on which date?
My lord,
This is on
the interim order itself, my lord. The interim order he has annexed, my lord. My lord may see.
which number? 52.
52, my lord. My lord had, however, it is made clear that any such for such fresh connection in the premises made to the rest shall be subject to the outcome of the writ petition. My lord, he did not even apply. So, my lord, it is not that he wants a connection. It is not that. If you would have wanted a connection, you could have gone and get a connection, my lord. It is only on the lieu of just showing that we have defaulted. His entire thing is that he needs a compensation of 10 lakhs rupees. That is there in his written argument. So, my lord, the intention is not to get a connection. Intention is to show the court that there is an illegality by bringing some or the other, by reading wrong provisions, by reading format 8, by not applying the proper application, by not showing the court that which document has been shown. His entire reimbursed compensation for causing physical and mental harassment to the petitioner 200 lakh rupees, 10 lakhs. In a writ court, my lord, are we going to decide the damages? And if the damages are there, he may go to the lower court, trial court, and file a civil suit. So, my lord, this entire proceedings that he's been trying to initiate, that my notice has not been served upon me, notice has not been served upon me, is a rhetorical statement again and again, my lord. His My lord, our reply, my lord. My lord, page 70, my reply starts, my lord. My lord, at page 73, I have made a categorical statement. The petitioner failed to pay the electricity due since May 2020 before the last date of payment, and therefore his electricity connection was temporarily disconnected on 20th August 2020. Thereafter, the respondent issued the permanent disconnection notice on 16/11/2021, wherein it was categorically mentioned that your electricity supply has been disconnected with effect from 28/2020 due to non-billing amount of 13,706. And the said amount is not paid within 45 days of this notice, the electricity supply will be disconnected permanently. Accordingly, after 45 days due to non-payment of the amount, the petitioner's connection was disconnected. A letter was also issued on 8/4/2022 informing the petitioner about the said disconnection and applying for fresh connection if he wants to enjoy electricity connection. We had given him an opportunity that you apply a fresh connection. Still, he did not apply. And now my lord, look in the reply to it. He has said it that it has been held repeatedly by various high courts and even at page 94. The notice of disconnection continued in the bill is not valid and a separate notice in writing is required to be issued and served as per section 171 of the Electricity Act. And the said mandatory requirement is not followed, a disconnection is invalid and the consumer is entitled to only restoration of connection, but even damage and compensation. Even in the reply, he is only asking for compensation and damage. And my lord, he has been relying on a Supreme Court judgment. My lord, which Supreme Court judgment says that that section 56(1) has to be given on a separate platter altogether? It is a part. It's the judgment which he has shown is of Rajasthan High Court. That has no binding in this court, my lord. There is a single judge judgment. So rightly, the court, the honorable court, our honorable court has rightly held that the disconnection notices itself is a part of the bill, and a 15 days time is also given. And my lord may see page 95. Payment of the damage of loss caused to the petitioner inability to rent out the said premises till the electricity supply is restored at the rate of rupees 30,000 per month, with monthly society dues charged with the petitioner being to the society without utilizing the premises. Then compensation for causing physical as well as mental harassment agony to the petitioner to the tune of at least rupees 10 lakhs. Page 96. This is part of his reply. So what is the bond intention, my lord? My lord, I would like to read out section 56(1) once again for this. My lord, may I? My lord, where any person neglects to pay any charge of electricity or any sum other than the charge of electricity due from him to a licensee or the generating company in respect of supply, transmission or disputing of wheeling of electricity to him, the licensee or the generator may, after giving not less than 15 clear notice in writing to such person and without prejudice to his right to recover such charge or other sum by suit, cut off the supply of electricity and for purpose cut or disconnect any supply line or other works being the property of such licensee or the generating company to which electricity may have been supplied, transmitted, distributed, or will, and may discontinue the supply until such charge or other sum together will any expense incurred by him in cutting off and reconnecting supply are paid but not longer. So accordingly, my lord, we supplied him the notice along with the bill, and this is not only to him, this is for the entire consumers of APDCL. That a disclaimer notice has been given that if you do not pay within so much so and so, your electricity will be ignored. Yeah, your electricity connection will be cut. This is everywhere. It is not only him. It is with all the APDCL consumers of the APDCL that this disclaimer notice or this disconnection notice is there, part of the bill. And thereafter, part of the bill, as per section 56(1), we have given him the time that you pay within 15 days. He did not pay. Thereafter, we again issued a bill. And my lord may see, all the bills that has been raised, it is only on the area amount.
Mr. Sharma, take your.
No.
Sharma. Yeah, Electricity Act 2003. Electricity Act 2003.
My lord, I have a copy.
Mr. Sharma. Well, read section 56.
Well, where any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee, or in respect of supply, transmission, or distribution of willing electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person, and without prejudice to his right to recover such charge or other sum by suit, cut off the electricity and for that purpose cut or disconnect any electricity supply line or other works being the property of such license of the generating company through which electricity may have been supplied, transmitted, distributed, or willed, and may discontinue the supply until such charge or other sum together with any expense incurred by him in cutting off and reconnecting the supply are paid but not longer.
Now, as per section 56,
My lord,
you are supposed to give a notice
my lord.
that within 15 days,
Yes, my lord.
you have to deposit this.
Yes, my lord.
Or otherwise, your electricity connection will be disconnected.
My lord.
When you have said that, and this, you have to give 15 days. Right?
Yes, my lord. It is there in the bill, my lord. The due date is there.
Now, as per your own permission that you have disconnected
My lord.
the
electricity connected, temporarily disconnected, when?
My lord, on 28 August 2020,
2008
August 2020,
2020.
my lord.
This is from the date of the notice.
My lord, this is after we have supplied the electricity bill to him. Then after the previous, yes,
That means this is as per section 15(1), you are supposed to
yes,
give
my lord.
him notice giving 15 days time.
Yes, my lord.
And if in this 15 days time he doesn't pay, then the connection is temporarily
Disconnected, my lord.
Right. Now, this information of temporarily disconnection,
My lord,
temporary disconnection is to be provided in the format 18
my lord,
immediately.
my lord, it is,
Format 18 is to be issued immediately.
my lord, it was issued to him, my lord, may I just hear?
No, it was issued to him on 16/11/20.
In 21, my
It was
lord.
not issued immediately. Let us assume he received everything.
Yes, my lord.
Now, you are saying that the notice under section 56(1) has been issued
My lord,
through the electricity bill,
my lord,
right?
Yes, ma'am.
Because there is a particular clause in that particular bill.
my lord,
So it amounts to the notice.
my lord.
You have annexed the electricity bill
My lord,
of the petitioner
my lord.
up to from
Up-
page
84, my lord. Well, wait,
page
2020.
77
Yes, my lord.
to page number
84.
84. When did you actually give the notice to the petitioner under section 56(1)? When?
My lord, that every of my bill, my lord, from 77 to 81, 84, my lord.
Whether those electricity bills
Yes, my lord.
can be considered as a notice under section 56(1)?
Yes, my lord, because there's a my lord, it has been directly, it has been given under section 56(1). Yes,
You have temporarily disconnected the electricity connection to the petitioner as per you is on 28th of August 2008
My lord.
2020.
my lord,
In spite of
my lord.
temporarily disconnecting the electricity connection to the petitioner, you have been generating bills and provided to him. He may not be available in his house, but just served. Let us assume it was served. With that clause of disconnection notice.
Yes, my lord, cause of disconnection notice was given. My lord, I'll just,
Let us assume
yes, yes.
with the disconnection notice, you have disconnected on 20th of August 2020.
My lord,
But with that clause under 56(1),
my lord,
continued to be served upon the petitioner up to 12th of August 2021.
my lord.
Why?
My lord, I'll just show here, my lord. My lord, see, my lord, first of all, I'd like to read out
Let
the,
us, considering your submission.
Yes,
is
ma'am.
why you are asking you.
Yes, ma'am.
You are saying that should be amount that the notice under section 56(1)
Yes.
is itself in the
Bill.
electricity bill.
Yes, ma'am, I'll just show it.
Section 56(1) says
15 clear days. Yes, my lord.
15 clear days
Yes, my lord.
from the date of the notice.
On the date of notice.
And you have temporarily disconnected on 28th of August 2020. These dates are, that is why we are asking you. These
Yes,
dates
my
are
lord.
very
Yes,
valuable.
yes. My lord may see page 77.
Hmm.
At top, my lord may see the due date,
Hmm.
16/6/2020.
Hmm.
And my lord may see the bill period 1/5/2020 to 1/6/2020.
What is the date of notice in this particular bill?
My lord, the date of notice will be the date of note.
Bill that will be the date of notice.
Yes, my lord.
Is
Bill-
not it?
Yes, my lord. Bill date will be date of notice.
No.
And the bill and the due date will be 16/6/2020. Then within 16/6/2020, if you don't pay, then we will take action as per 56(1).
So in that case, this bill was not paid.
Yes,
You have-
accordingly,
you have issued the next bill.
Next bill.
You have not.
We did not took the provisions of
Exactly.
8.2.
56.1 you have not followed here.
No,
You
my,
have again reissued the notice.
my lord, may I just say here?
Huh.
My lord, the 8.2 very clearly says the licenses shall intimate the consumer in case of temporary disconnection in format within 24 hours of disconnection. That means within 24 hours of disconnection.
We are on 56.1.
Yes, my lord. On
So
56.
what has happened here?
My lord.
You have given him the bill
Yes, my lord.
on 1st of June, page number 77.
Yes, my lord.
1st of June 2020.
Yes, my lord.
Giving him a notice
Yes.
that you pay under section 56.1.
Yes.
Otherwise, your line will be disconnected.
Yes, my lord.
At any time
Yes, my lord.
due to non-payment of the dues.
My lord.
And in this particular bill, you have given the due date is 16th of June.
Yes, my
That's
lord.
15 days.
Yes, my lord.
And 15 days from 1st of June is.
Yes, my lord.
Right.
So
Come to the
there,
next bill.
after that, we give a next bill to him.
Next bill was given to him on 1st of July 2020.
20.
Similar.
Similar thing,
notice-
similar notice.
So the previous notice goes.
Yes, my
Issued re-notice.
re-notice was there.
Re-notice was given on 1st of June,
2020.
1st of July 2020.
20.
Again giving the due date was 16th of July.
16th of July.
15 days time,
My lord.
comply with. Then
Then,
he
my
did
lord,
not pay. He did not pay.
my lord,
Then you have issued
the third
on
bill.
third notice.
Yes, my lord.
See, it's since you have been generating new bills,
Yes, my lord.
the previous notice have gone. It was not compliant, so you have issued a fresh notice.
My lord.
So now come to page number 7.
My lord, it would not be like a fresh notice. My lord, may I just pray here?
We are on 56.1.
Yes, my lord.
So now other notices gone. Anytime you have said, anytime.
My lord.
That itself at any time cannot be. It should have been within 15 days as per 56.1. Very clearly you have mentioned in the disconnection notice, if you read
Yes,
every bill, under section 56.1 of the Indian Electricity Act 2003, power supply to your payment premises will be disconnected
At any time.
due to non-payment of area amount.
Ignore if
Not
already
already
paid. Yes.
Now, non-payment of any time means you have to specify. Anyway, forget that.
My lord, the specification.
Now, come to page number 79.
Yes, my lord.
This is a bill of 13th of August 2020.
Yes, my lord.
13th of August.
Yes, my due date,
Due
my
date
lord.
is 28th of August.
My lord.
2020. When did you terminate the electricity?
My lord,
Was
20,
it 15
my lord,
days?
this is 20, 20, not, it cannot be 28.
How can you not? 13 plus 18, 15 days.
Yes, yes, well, 28, 28,
Has to
August,
be 28.
28 August,
And
my
when
lord.
did you disconnect?
My lord, on 20th August 2020.
You have disconnected on 20.
Yes, my lord, this was 20th August 2020. My lord, this can be a
You have
type of,
disconnected on 20, not within 15 days.
my lord, may I just submit here? My lord, may see, my lord is coming to the conclusion here is this, that every time we are giving a notice, our notice period goes. My lord, may see,
See, that is why you have generated next bill. It
Yes.
is not zero bill.
my lord, it is a zero bill. My lord, see there, my lord, we have not charged any energy here.
You are not charging energy.
Energy, but his area will, only we have added the area.
Generating a new bill means what?
My lord, may I just submit, my lord, submit
Generating
here.
means new bills what you could have disconnected.
My lord,
Since you have, you know the law of acquisitions very well.
yes, my lord.
Once you have not disconnected within that period, you have generated a fresh bill.
No, my lord, may I just submit here?
Now, just tell us,
Ma-
since when you have not generated the electricity charge?
My lord, may I just submit
The
here?
person was not in the house for 2 years.
My lord, may I just submit here? May I just submit here? My lord is in this presumption, my lord has taken the presumption that we have been generating bills and asking him and generating bills despite the disconnection, and even after disconnection, we have been generating bills. My lord, that is not the case. My lord, the bill that we have raised is only with the arrear. Only with the arrear, the accumulation of an arrear. If, for example, my lord, if a person does not pay income tax today, his income tax notice.
See,
So similarly, in my
now,
case,
now it's okay. It's fine. See the graph, page 77,
yes, my lord.
consumption graph.
Yes, my lord.
Last month's bill, consumption graph is there, page 77.
Yes, my lord.
Very good. Come to page 78.
Yes, my lord.
Again, energy consumption last month.
Yes, my lord.
Now come to page 79.
Yes, my lord.
Last month bill consumption.
Yes, my lord.
Then you come to page number 80.
Yes, my lord.
What is the consumption?
My lord may see the energy charges, no zero energy charge.
We are asking you the energy consumption.
My lord, this is the,
This is your bill.
my lord, yeah, this is my bill. My lord may see the rate.
And
But
then it
this
comes
is,
to page number 82. what
Yes,
is
my
the
lord.
consumption?
my lord may see the energy charge. The first amount 0, the next amount is
That
0.
means whatever is there in the remaining portion of the bill is bogus.
No, my lord, it's not been bogus, my lord. It is,
See, how then you are saying this? It is your bill saying that last month's bill's energy consumption.
my lord may see,
If the
my lord may
petitioner-
see on the right
if
hand
it is
side, my
zero,
lord.
That is the reason I'm asking you.
Yes.
If the consumption was 0, why this graph?
My lord may see on the right hand side, my lord. My
Whatever
lord,
is
what is
there.
this, my lord? This is energy come
That
the
means
last.
what? That graph is bogus.
No, my lord, this is not about, this is not about
Mr.
defining.
Sharma, then why you that graph? Why this graph shows? the
My lord,
consumption?
whether the figure is, my lord, the figure is more important here, my lord. My lord, the figure is very much clear.
Something is wrong in this bill.
My lord,
Then why at page 82?
my lord,
Why this at page 82? When there is no consumption, why this particular consumption?
my lord, what does it
Why
show?
the graphs are different?
My lord, what does it show, my lord? It just shows that the 7.5 energy, my lord, has been 0. Well, it has been 0 all the time.
It is the graph.
And my lord, this
Mr.
is,
Sharma,
my lord, may I
Mr.
just-
Sharma, it is relates to consumption and consumption of what?
my lord,
Not food, not biscuit, not
my lord, may I
wax,
just- my lord, may I just-
electricity.
I absolutely understand what my lord is coming. My lord, without energy charge being, with my lord, where would the person pay his bill from? From the amount that is pointed in the bill. The amount that is pointed in the bill is 0.
What
My
is
lord
the
may see.
Energy consumption.
My lord, the energy, whether we have charged anything for energy consumption, whether there is any charge of energy consumption
If
here.
there is no energy consumption.
My lord may
then
see energy charge is 0. Energy
why
charge,
that graph?
my lord,
why
the
that
graph,
graph?
what does the, my lord, there's a graph, what does it indicate? It just indicate, it's just the energy consumption of last month bill. That is what, my lord, it says. And my lord, whether this graph, what does it? It does not indicate the energy charge. So energy charge directly indicates the charge breakup on the right hand side. My lord may see the 7.4 unit is 0.
That is the reason we are
So, my lord,
asking you. If you are relying on
the
that,
bill.
the bill is the notice.
My lord, may I just,
Probably. Then you please come to page number 83. There is no energy consumption, bill, no graph, no energy consumption.
my lord, these bills are computer generated, and my lord, these bills, my lord, one thing, my lord, is not, my lord, one is not following one parallel thing. My lord, the
If
one
you are
parallel thing that my lord,
Relying on this bill as a notice, you have to rely everything,
yes, my lord.
not in part.
So, my lord,
The graph consume them electricity or the.
no, my lord,
energy is a
whether,
part of it.
my lord, whether those graph injection has been, whether this energy consumption has reflected to any charge therein. It is no, my lord. There is no charge therein. No
Last
charge.
month's bill.
No charge, my lord. There is no charge at all.
Ultimately, you have.
And my lord, whether in the any of their plea they have taken that this
Not
energy
required.
consumption is bad.
It is your own statement that it is the notice itself, the bill itself is the notice.
Yes, my lord.
If the bill itself is the notice, you have not given 15 days time.
But we have given 15 days time.
That
At
is
top, my
come
lord.
to Page number 79.
Yes, my lord. 15 days time, my lord.
If the bill date is 13th of August 2020,
Yes, my lord.
and as per section 56(1), it is 15 days.
Yes.
You have terminated the electricity on 28th.
Yes, 28th
Within
August.
7 days, not within 15 days.
My lord, that is what I was coming to, my lord. That was what I was coming to. My lord, first question, my lord.
Can you change the section by way of regulation?
My lord, we have not changed the, my lord, section 56 has been squarely covered under, by giving the power under section 50 of the Indian Electricity Act. That is why the mode of.
15 days time you can.
No, we have not reduced the 15 days time at all. My lord, we have not reduced at all. My lord may just come to this. My lord may see in none of his pleading has he spread that we have
Not
charged.
required. Did you comply with section 56(1)?
Yes, ma'am. Yes, my lord, we have complied.
From which date?
My lord,
Bill.
my lord may just submit here. My lord may see from page 77 onwards till page 82. There has been a 15 days period given to him. And these are, and at page format 18, we have clearly stated that this is to your with effect from.
When the format 18 is required to be issued.
My lord, it says, that is what I was coming to, my lord. The licensee shall intimate the consumer in case of his temporary, in the format 18 of this, in this code, within 24 hours of disconnection.
When
Not
you disconnect.
within 24 hours of disconnection. That means the moment we disconnect, then we have to inform.
When did you disconnect?
My lord, that is where we have, we have come in and said that 16/11/2021 that you are requested to remove the cause of disconnection and intimate the office of the earliest.
As per your regulation, format 18 is to be issued when?
My lord, as per my regulation, the format 18 has to be issued after we disconnect 24 hours after that, and accordingly we have done that.
When was it, you have disconnected on 28th of August 2020? When did?
No, 20th of August 2020 was the temporary disconnection, my lord. My lord, that is where the confusion has occurred. That is what I'm trying to clear out. My lord, disconnection is of two parts. One is temporary disconnection and one is permanent disconnection. 8.2.2 clearly states about that the licensee shall intimate the consumer in case of his temporary connection in the format 18 of the code within 24 hours of disconnection. My lord may
It
see.
is not with the temporary disconnection.
My lord may see page 403.
According to you, it is not primary, temporary disconnection, it is the permanent disconnection.
Format
Right?
18, my lord may see format 18.1 again. Intimation after temporary disconnection, my lord. It is not before temporary disconnection. It is after temporary disconnection. Heading itself says, my lord. Intimation
Your
after,
8.2 is which page?
my lord, page 403 it starts from, it will be at page 404. If my lord have got it, my lord. The licensee shall intimate the consumer in case of his temporary connection in the format 18 of this case within 24 hours of disconnection. And my lord may see the top of the head. It is
You are reading at clause.
clause 8.2.2, disconnection of on other reasons. And thereafter provided, however, the supply shall be disconnected. If only the cause of disconnection is not removed within the notice period. That licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnection.
Please come to page, clause 8.2.
Yes, my lord.
8.2 relates to what?
Temporary disconnection.
Now, 8.2.2 comes under what? clause?
8.2.2 comes under temporary disconnection.
Please come to page number 406.
Yes, my lord.
It comes to what?
Permanent disconnection.
And that relates to a separate category. of-
Category altogether.
Now, this 8.2.2 subclause J, the last one.
Yes, provided a notice period of all disconnection shall be 15 days, except in the case where a disconnection is requested for by consumer, unless specific provision for shorter or longer notice period is provided in any rule or regulation or in any act of disconnection under specific region as mentioned under section D and G above. This is D and this is G. Then, however, the supply shall be disconnected only if the cause of disconnection is not removed within the notice period. Thereafter, my lord may see, the licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnection. Now, my lord,
This is not the permanent disconnect. This
No,
is temporary disconnect.
my lord, that it is, my lord, it cannot be permanent disconnection because my lord may see the format 18 start. It is even the
This
it-
clause format 18 or department, whatever saying that within 24 hours comes under temporary disconnection of clause 8.2.
my lord, may I just, my lord, if my lord, if what my lord is fallen from my lord's, my lord, if that would have been then the format 18 would not have been intimation to consumer after temporary disconnection supply.
Hmm?
Format 18 heading would not have been intimation to consumer after temporary disconnection of supply. It should have been before temporary connection of supply.
No. You're right.
Because my lord,
After-
let me explain it, my lord.
You are supposed to issue format 18 After.
Temporary
24
disconnection, yes. So, and after temporary connection and after permanent connection, we don't have to.
That's right.
Yes,
But when did you intimate?
my lord, we intimated him on 16/11/2021.
Is it 24 hours?
My
Or
lord.
temporarily disconnected?
My lord, that is where I was coming to, my lord. 24 hours we did formatted it within 24 hours of disconnection. That means once you do the temporary disconnection, you intimate him. And
When-
accordingly, we
when-
intimated him
When
on 16/11/2021.
the rule says what? Regulation says what?
Regulations says the same, my lord. It says the licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of this disconnection.
So when you have disconnected,
We have this, my lord, on 16/11/2021, we have given the reason that your
we are
compare,
not asking you that question, Mr. Sharma. We have very specifically asked you when you have disconnected.
my lord, we have disconnected on 16/11/2021 when the notice was given to him. Before the notice we have given to him.
Then why you have mentioned the date of 28th of August 2020?
My lord, that is where I was coming. This is the year has been tempered with effect from. It's from effect from, my lord.
No, that means what?
My lord, there are two types of
See,
disconnection.
neither you are an Englishman, not I am an Englishman. We can understand the English
Yes.
from reading it, right?
My lord,
But
that is
from the reading of your class that you have temporarily disconnected.
with effect from 20th.
That is mean what? So when was you are supposed to give the notice?
My lord, that is where I was coming to, my lord. The notice was only supposed to give after we do the disconnection.
When did you disconnect?
My lord,
With effect from which day?
with effect from 20th August.
So what will be the 24 hours after 28th of August?
My lord, that is where I was coming.
Fine. What else? We understood. Then what?
My lord, my lord may say at the bottom, if the cause of disconnection is not removed to the satisfaction of this
Then
office,
permanent disconnection.
and above amount is the 40, you shall be disconnected permanently
That's right.
without any further notice.
Okay.
So my lord may see to this, if my lord is coming to that, we have not given the term. He has been already known about it in his legal notice.
That's right. We have seen that. Second para he has mentioned that since 2 years.
Yes.
Disconnect. We have seen that.
So my lord, the entire, my lord, the learned single judge, by holding it as he is directly hold, my lord, may see, as I read out the paragraph.
Kindly come to page number 48.
My lord.
Page number 48.
My lord.
That's the legal notice.
Yes, my lord.
Okay. When the petitioner paid the amount,
My lord, the petitioner amount paid was at page 46,
that was on 29th of
March 2022,
March 2022, along with the reconnection. payment.
reconnection payment. That was after the PDC bill.
And when he approached, he came to know that reconnection was not done in spite of this payment, right? Of 600. Then he has issued this notice. Is not it?
My lord, that is what his contention is.
This notice was given to you only after reconnection was not done.
Yes, my lord. So, my lord, may I just come in here, my lord? My lord, what I'm submitting here is this. My lord, the situation would be such that it was the COVID time.
Now, just tell us the bill at
My
page
lord.
45. Was there any reason for payment of 600?
Yes, my lord, because it was a PDC bill. This is a PDC
Payment
bill.
of 600 rupees for reconnection.
No.
Is there any?
That was
Is it
not,
not
we never asked him for reconnection charges.
Now, this amount of 600 was received by you on what basis?
My lord, it was received, it was given to us, and that is why learned single judge said that whenever he apply for the new connection, that will be adjusted.
Now, please come to page number 47.
Yes, my lord.
Receipt number Date is 29th of March,
2022.
2022, time is 3 p.m.,
Yes, my lord.
past 3 p.m.
Yes, my lord.
Now, receipt number is there,
Yes, my lord.
invoice number is there,
Yes, my lord.
consumer number is there.
Yes, my lord.
Name is there,
Yes, my lord.
bill amount is there,
Yes, my lord.
due amount is there,
Yes, my lord.
payment is made by what? Mode of payment,
Payment mode cash.
then why did not you object?
My lord, at top, my lord, may see there is a reconnection charges and disconnection charges. RC and dash DC. So this is the disconnection charges that we have taken.
RC/DC.
DC. RC is reconnection charges and DC is the disconnection charges.
Before the disconnection charges, have you intimated that this is disconnection charges?
My lord, it is as per the notice 56(1), it is already there. At the last bottom line, that any reconnection or disconnection charges can be borne by the consumer. The last line of 56(1).
Which page 77 is it there?
My lord,
Which 56(1) notice, where is it? You have mentioned.
at the end, my lord, that at the bottom, that express income of and are paid but provided that it's an end it's maintained. And my lord, I have given even straight in my reply also.
Your disconnection notice,
Disconnection charges, my lord.
disconnection charges, where you have mentioned that? In every bill?
My lord, at para 70, page 75.
No, in the bill or when? You have said that you have been intimated. Where is it?
No, my lord, I have said that I have given my reply that why 600 rupees has been charged.
Hmm.
In my para reply at page 75, para 6. Para 8, page 75.
Hmm.
However, the said fees would only be applicable with regard to temporary and not permanent disconnection. The said fees had been paid for disconnection charges. A clear reading of the bill indicates the payment is either of the reconnection or for disconnection charges. In the instant case, the payment was taken with regard to disconnection. My lord, because after temporary connection, only reconnection can happen. And after permanent connection, there will be disconnection only.
Did you mention in the bill that there was a disconnection charge?
My lord, the bill only contains 1656(1), my lord. For disconnection charges, there is no notice has to be given.
It should in the bill.
My lord, none of the provision said so, my lord. Nor the regulation.
What is the provision for charging disconnection charges?
My lord, it is here. You are requested to remove the cause of disconnection, intimate desire. You are also requested to pay towards disconnection and reconnection charges.
Which page?
Format 18, your page will be, my lord, page.
It is in the format 18.
Yes, my lord. You are requested to pay a sum of rupees so and so towards disconnection, reconnection charges, and so mentioned if any other dues are to be deposited with a detailed breakup.
No, format 18 at page 502.
Yes.
It's like this.
You are requested to remove the cause of disconnection and intimate this office at the earliest. You are also requested to pay a sum of rupees so and so dash towards disconnection and reconnection charges.
What is the amount in that notice you have said? If format 18 you have properly given, that amount should have been notified in the notice. Come on, let us.
That amount has not been reflected in this.
That is incomplete. That means format 18.
That has not been That has
Right,
not been
that
mentioned.
format 18 accord that now you are saying that format 18 did not disclose anything.
That amount has not been mentioned.
Then why you have charged that? Why I have received it?
My lord,
Connection charge or disconnection charge when it has not been mentioned. If you are relying on this is a format 18 issue, if you have not mentioned, then why you have received that amount in cash as disconnection charges?
may I just submit here, my lord? My lord, disconnection charge of rupees 600.
See, you have not mentioned in your format 18, but you have charged, you have received. Why? Why?
Because once, my lord, he has, the PDC
We
bill,
understood.
yes.
Since disconnection was, you have charged, but what is the amount? Without in notifying the amount, why have received that amount? Who informed him that he should pay 600 rupees?
My lord, he was informed, my lord.
Who? By which notification you have informed him that he should require to pay 600 rupees?
So, my lord, whether or not any of the plea has he taken the
Not
disconnection?
required. We say it's not required, he's the consumer. You should clearly give him because you are the supplier. Where those terms and conditions?
My lord, I'll just show it to you, my lord. My lord may see here at page 2, page 49 of his legal notice.
That is after receiving the amount.
No, before receiving that. Yes, he has given an admission, his own admission. Anyway, when we went to the office to inquire about the matter on 29/3/2022, we were told by the person who was sitting in the bill, received in the same day, was the last day for the payment. And if it was reconnected and apart from the bill, we have to pay an additional amount of 600 as reconnection fee charges. So 600 rupees was told to him.
As a reconnection fee charges.
So my lord,
Not, that is why if you have not notified him that this amount has to be paid as a reconnection or disconnection charge, you have not notified.
My lord,
But it was intimated to him that as a reconnection charge, he is required to pay 600.
and my lord, in that aspect, my lord, the learned single judges also says the respondent should refund the reconnection charge company on application of same being made. So we'll refund it, but he has not made any
Now
application,
just tell us one more, you just clarify one more thing.
my lord.
Please come to page 45.
Yes, my lord.
When did you permanently disconnect?
My lord, as per the notification 16/11/2021, we gave a date, and after that 45 days were given. And my lord may see this bill is of 14 March 2022. So my lord may see this is after 45 days of the intimation notice. Within 45 of this notice, your supply shall be disconnected without any further notice. And the bill is of, my lord, 14 March 2022. So,
Where is the notice for the permanent disconnection?
my lord, there is no notice
You
required
are
for,
supposed to disconnect within 45 days, right?
yes, my lord.
From the date of
From the date of format 18 being issued, my lord.
former date of 18 minutes.
And it shall be without any further notice.
So prior to temporary disconnection,
Yes, my lord.
sixteen 11, you have should date 18 14 8 notice, right?
Yes, my lord.
Why the fixed charge is paid for? Can you tell us?
My lord, that is in the
Because-
definition.
Uh,
It is at section fixed charge shall be as per provision prevailing tariff order issued for the licensee by the commission. The Assam Electricity Regulatory Commission gives a tariff order where there is a fixed charge. And tariff order is defined in section 2 sub 72. Tariff order in respect of a licensee means the most recent order issued by the commission for that
Is
licensing.
that available in regulation or in the act?
The tariff or it is there in the regulation itself. I would not be knowing the page number of that, but here it is there.
There's a definition clause.
Yes, there is a definition clause. 1.4.1. $42, it will be fixed charge.
This regulation, it is not there.
It will be there.
It should have come after E, right? It is not there.
My lord,
There is a definition clause,
I'll just find it out for you, my lord. If my lord may.
definitions and glossary, 2.1.
No, my lord, 1.4.1 definition and interpretations, my lord. May I mark it, my lord?
Tell us the page.
My lord, the page will be 305. And 308.
When a consumer is required to pay that, while you supply the electricity,
Every time, my lord. Every
Huh?
time there's a fixed charge is there.
every time why that is required to be paid? Just fixed charge.
Man, I'll just show it, man. Because there is an act, my lord, that is the tariff, my lord, I'll show you the way the bill is made. That will be how the bill is taken into effect. My lord, but in none of the
No, tell us for our understanding.
yes, ma'am. My lord may go to 6.3.5.
Billing.
Billing, my lord. Contents of energy bill. Modal bill format. My lord may see billing details. Item-wise details for the current month as well as the past areas shall be furnished. Energy charge, fixed charge, meter rent, capacitor charge, other charge. So this is a part of the bill. Total current month demand and everything, my lord.
So, please come to page number. $77.
My lord.
There is a demand and fixed charge is there in that
Yes, my
bill?
lord.
Okay. Then there is also electricity duty.
Yes, my lord.
Then there is area principal and there is a surcharge on the area.
Yes, my
You can
lord.
understand.
My lord will file at 14 at the next page.
No, please come thereafter.
Yes, my lord.
Please come to page number 78.
My lord.
There is again a fixers. So every month there is a fixers.
Yes, my lord. Every
There's one fixers, then the
fixed charge is on the unit, my lord. The meter, the
electricity duty. Right.
electricity duty, yes, my lord. Fixed charge and electricity duty is there.
Then it goes to the, because not paid, it is again goes to the area.
Area, my
Area
lord.
is increasing.
Yes, my lord.
Now, again at page 79,
Yes, my lord.
fixers is there.
Yes, my lord.
Then electricity duty is there.
My lord.
Not paid, it goes to the area.
Yes, my lord.
Page 80,
Same thing, my lord.
fixtures. Then you have the electricity duty. Nice. Right?
Yes, my lord. This fixed charge, electricity duty, these are all goes to the government. As it's a rate of the fixed because we buy electricity. We have to give electricity. So these are the fixed charge. This is why the regulatory commission is there. They regulate and they give us charge. And
up to page 79.
Yes, my lord.
Total bill amount was 4,522.
My lord, my lord, these are not all the bills are not here, my lord. These are, yes.
Page 17 and it's your affidavit only.
Yes, my lord.
Because you have an X, not the.
Yes, yes, my lord.
4522.
Yes, my lord.
The next bill
Yes, my lord.
is of 2nd of September 22.
My lord.
What is total bill is 911. This is after your temporary disconnection.
Yes, my lord. This is after my
What is 911 amount again?
Yes, ma'am. There's 911 total bill amount there.
This time it has become 911.
Yes,
That
my
means
lord.
something was paid.
No, my lord. No, there's nothing been paid.
See, there is no areas.
Yes, no, my
Area
lord.
principal is zero. Just see in that bill.
My lord may see here. My lord may just see.
We have seen
Yes.
that you have annexed the area
Yes, yes.
principal has
I'm
become zero.
I'm coming to it, my lord. My lord may see 4522 is there. There is no payment done for him. But because there was a temporary disconnection. Now, my lord may see the first bill, page 77. My lord may just, I'll just clear it, my lord. Just give me 1 minute.
Please come to page number 80.
Yes, my lord.
Current demand is 911.15. Outstanding amount 0.
My lord, I'm coming to it, my lord. May I just coming here, my lord? My lord may see the bill of 77 once. 77, page 77, my lord. My lord may see there's an outstanding amount of 1,738. Net bill amount is 2,667. My lord may see this. Now, my lord may see this amount goes up to 4,522. Thereafter, the temporary disconnection has happened. Then whatever the bill was of earlier, that is not being calculated. Only the current demand, that is only the area has been demanded. See 911. That is why this
is not area.
No, my lord, 911 is sorry, the 911 is the fixed charge, electricity duty, and the meter rent.
That is why.
Yes.
Why not the area?
My lord, I'm coming to it. My lord, then my lord, see the new area again starts from the next bill.
Next bill. Yes, because 911 is not paid.
Yes, that is 1802. My lord may see. Then the third 4/3/2021. Again that comes up at 3587. And my lord, this is the difference is there because this is of October. Again, I have given of April, March 2021. 4/3/2021. So there were 3 months in between. This is after the disconnection. 20th August, we disconnected. This is the bills after temporary disconnection. Now only my lord, the bill is separate. (911), my lord may see. Then it has been increased. Then this is of 4th March. Again, the same thing has been accumulated. Then 33/2021.
Mr. Sharma,
My lord.
page 80,
Yes, my lord.
see the bill period,
My lord, bill period is from 1/8/2020 to 1/9/2020.
right?
Yes.
The next bill,
The next bill is of 1/9/2020 to 1/10/2020. Then, my lord, 2/12/2020 to 1/1/2021. My lord, there were bills issued thereafter, but whatever bills we wanted to show
that
that.
is why, show us why this 911. It has become 1802, right?
Yes,
Now, here, why this outstanding at, it has become 3664 in the 82 page number?
no, it is 13706, my lord. The 13706, my lord may see
Please
111157.
come to page number 82.
Yes, my lord.
Where is that outstanding 36? Come to the bill period, billing details.
Yes, my lord.
Current due is 912.
Yes, my lord.
Where this 366 has come from?
My lord, that would be the bill that would be previous to that, which I have not annexed here
It
yet.
was not there in the previous amount, previous bill.
No, my lord, that is of 2020. This is of 2021. 1/1/21 to 2/12/2020. My lord, may see.
Oh, that's what we are saying.
Yeah, my lord, 1 month bill is not there.
Why?
My lord, we did not annex it, my lord, because we wanted to show that we have been issuing him bills. And my lord, this is, if my lord requires, we can produce it. If my lord may require, because it will be in the consumer number will be there, this bills will be there.
Okay, fine. You are saying that this, for these 2 months, he did not pay. This is the 3rd month's bill.
Yes.
That means 1000, let us assume it's of 9, forget 900, 1000, 1000, 2000.
Yes, my lord.
Earlier outstanding was 911. That is, let us assume 1. Then again 1000, 2000, then 3, okay, 4. That is what not paid. Okay, fine. Then
my lord may see at 82, it is 1/1/2021. That is the January 2021. Then again, I have given of 1st February 1/2/2021. My lord, 5665. So my lord may see the calculation. It is appropriate, proportionate. Then again, I have given of 2/7/2021 to 1/8/2021. And thereafter, till 9/10 is also there. September and November is also there. If my lord requires, I can produce it. I can produce it because those were never into a question here. So, my lord, this was never into question, and that's why, my lord, they have never ever challenged that this billing is wrong or this amount is wrong. They've only said that we were not given notice under section 56(1). So only we wanted to show that we have been giving you bills upon bills upon notice upon notice.
fine.
So my lord would like to see the originals once.
Not required.
So my lord, before my lord gives the opportunity, my lord, I would just like to clear this point once again, my lord, because this would, what my lord's mind has been, I would like to just take up my lord to one provisions once, my lord. My lord, there is a provisions in our six point 3.10, which says billing in case of disputed bills. In event of any objection in respect of the bill amount, the consumer may lodge a complaint in writing before the designated officer as mentioned in the energy bill. For 2 years, my lord, there is a provision that if you have any dispute regarding our bill, you may intimate us. Or you may.
Is it available in the bill itself? Will you communicate these provisions in the bill?
My lord, these are provisions of the code, my lord. So, my lord, this, my lord, for example, my lord, let's take a common man. He comes and says that today I have been charging 1,000 rupees, but tomorrow my bill has come to 3,000 rupees. He first goes to the help desk. The help desk says, okay, you pay this amount, dispute, and you give a disputed. Then they refer the matter to the consumer forum. And there, the line manager check and everything is checked. So that is the procedure that is adopted. That is the procedure that is adopted, and then the ombudsman and everything is there. The consumer grievance redressal forum is there. Whatever into. So he never raised a disputed bill. He invoked Article 226 only on the account that notice under 56(1) was not served upon him. And because of that, he was not able to make payment. So, my lord, in that context only, he had come to read 226. If he had anything with disputed bill, my lord, I'm not done, my lord. Just 2 minutes, my lord. I'll just take 2 minutes of my lord's time. My lord may see, it is learned single judge finding, my lord, at page 108. Page 108, my lord. Page 108, my lord. My lord, Mrs.
Yes.
However, in the body of the said letter, my lord may see, at this analyzes the materials on record. Yes, this is a reply. This is their handwritten note, which learned single judge has pointed. It is clear, if at all it was given only on, say, where it was temporary, for which no notice was given. Despite that, my lord, by referring to Prem Kotak's judgment of the Supreme Court at Rahmatullah Khan, my lord is aware of those judgments, the recent judgment. My lord, 116, page 1111. The herein above referred advocate reply dated 8/4/2022 indicates the respondent had mentioned therein that the notice before permanent connection was served upon 16/11/2021. So, my lord, the entire issue that we did not issue after 24 hours, my lord, when he was served 16/11/2021, he had 45 days to pay the amount, my lord. My lord, that has not been looked into, my lord. He had 45 days to pay the amount. Despite that, he did not pay. And my lord, I am telling it on record, my lord, we are still ready to pay him electricity. We are still ready to give him electricity connection, but we can only give him new electricity connection. He is not ready to take it. He is only ready to take the old connection and that we cannot provide, my lord, because now the metering system has changed. And my lord, the paragraph 20 is very important, my lord.
Yes.
That it appears that in respect of payment of electricity bills, there are 3 aspects. Firstly, if the energy charge is paid before the due date of the current electricity energy bill, the supply of the electric energy would be maintained or continued without interpretation. Secondly, if the energy bill is not paid within due date, the respondent had a right to temporarily disconnect energy supply. Thirdly, if the payment of energy charges is made after the electric energy supply is permanently disconnected, there can be no question of reconnection even after the payment is made, and the consumer would have to apply for fresh connection. And my lord, for this finding of the learned single judge, there is nothing on appeal, no grounds.
Look into.
My lord, that is what I'd like to pay, my lord.
But it's,
Very short.
yes, but I'd like to give a very short reply, Milad. Very short reply, Milad.
Yes.
Milad, unfortunately, Milad, there have been certain misrepresentations before this honorable court, which have to be brought before your honorable lordship's attention, Milad. The very first instance is that the submission of the learned counsel for the respondents that format 20 notice is not applicable to the petitioner is absolutely wrong and against the records of the case itself. Now, Milad, they give a hypothetical and an imaginative distinction between different types of consumers, which is not provided in the Act or the Supply Code in terms of service of notice. Now, before anything else, Milad, before taking your lordships to the Act itself or the code itself, I'll take your lordships to the impugned judgment and order. We are in appeal, they are not in appeal, Milad, so this judgment is binding on them. I'll take your lordships directly to the relevant portion at page number 107 of the paper book. They say that format 20 is not applicable to us because there is no agreement. That was the specific assertion. And what does this?
Different type of consumer, my lord will file a 4.4.
I'll submit.
4.4, it is there.
I'll submit.
So there's no wrong submission.
Like I said, my lords, no distinction in terms of service of notice. Here, page 107, first paragraph, third line. Therefore, by operation of proviso to regulation so-and-so, the agreement between the petitioner and APDCL is deemed to have terminated. This is the finding of the learned single judge. Now let us go to the meaning of agreement, my lord. The meaning of agreement, which is available in the code itself. I'll quickly take your lordship to the definition clause 1.4.1, clause number 4. Yes, plus. Clause number 4.
Which regulation?
Definition of agreement, 1.4.1 of the code. Agreement means an agreement entered into by the distribution licensee and the consumer. There's no distinction. There's no distinction between whether an agreement would be different for different kinds of consumers. It just says, it just talks about an agreement that has to be entered into between the licensee and the consumer. And who is the consumer? Well, without any agreement, how can we draw electricity from them? There has to be some agreement. How can they charge money from us if there is no agreement at all? There has to be an agreement. They say that there is no agreement. The learned single judge has also recorded that there is an agreement. Now, again, this brings us to format 20.
You said agreement is an agreement entered into by the distribution licensee and the
consumer. We're a consumer. So there is an agreement. And let us go to the definition of consumer also. Clause number 24. Consumer means any person. Again, any person who is supplied with electricity for his own use by a licensee or government or any other person engaged in the business of supplying electricity to the public under the Act or any other law, so on and so forth. In this code, the term shall also include persons who have applied for an electricity connection, persons whose supply has not yet commenced and even after connection has been provided, or whose electricity supply has been discontinued for non-payment of dues, etc., but whose connecting service lines, electrical apparatus has not been physically dismantled or whose agreement has not been terminated. So this talks about agreement also and consumer also. There's no distinction as laid down by the Learned Counsel for the respondents. Yeah, but consumer means any person. Of course, like I said, of course, there has to be an agreement between us and the licensee organization. Otherwise, in the absence of an agreement, how will we draw charges from them? How will we draw electricity from them? How will they charge money from us? There has to be some agreement. They say there is no agreement. They say, since there is no agreement, format 20 will not be applicable. But for that, let us come to format 20 also. Format 20 also, Milords. Since I do not have a copy of that, Milords, the paging will be different. Format 20. I have a soft copy. Format 20, Milord. Intimation to consumer after termination of agreement. Your Lordship, mechanic. Right after format 18.
Yes.
Format 20, my lord. Intimation to consumer after termination of agreement. No distinction again laid down here. Nothing of that sort, my lords. Format 20 flows from the clause from the code itself of permanent disconnection, which is at 8.3. The last line, my lords, at the cost of repetition, I'd like to quickly go through it. After termination of all agreement, the licensee shall intimate the consumer in the format 20 of this code. Again, Milords, I fail to understand how this distinction is being brought about by the Learned Counsel for the respondents. I am a consumer. There is an agreement between me and the licensee and the distribution agency. Then they are mandated. They're bound to serve me a copy of format 20 notice right after permanent disconnection. Right after permanent disconnection. the submission regarding commercial or private, all of that does not come into play. That is absolutely baseless and unfounded, my lords. So far, my lords, no reason is forthcoming from their end as to why format 20 was not served to us. My lords.
Can we read 8.3?
The supply shall be disconnected permanently in following cases. On the termination of the agreement, if the cause for which the supply was temporarily disconnected is not removed within the notice period, provided that if the service of the consumer remains continuously disconnected for 180 days, not being a temporary disconnection upon request of the consumer, the agreement shall be deemed to be terminated on the expiry of 15 days or after expiry of the initial period of agreement, whichever is later, without prejudice to the rights of the licensee or the consumer under the Act for recovery of an amount due under the agreement. So here, let's say, it talks about the conditions under which permanent disconnection can be effected. We have no quarrel with that, but we have a problem with the non-compliance of the last part, which is service of format 20 notice to us. This has absolutely, admittedly, not been done by them. They said that it's not applicable. We're saying that it is applicable. So what is not disputed is that it was not served. Now coming to format 18. Format 18, the question of 24 hours has been very conveniently deflected, my lord. The Act, the code, utilizes and employs the word shall. Plus, I do not need to remind the learned counsel with the respondents the implication of the word shall. Shall makes it binding upon them. The code does not use the word may. It uses the word shall, which means within 24 hours. They say after disconnection, temporary disconnection. Of course, it has to be after temporary disconnection, but it has to be within 24 hours of disconnection. Temporary disconnection. Again, the legislative intent was that, my lord, so that the consumer is made aware of the temporary disconnection and then they're given an opportunity to remedy it. Here, if, my lords, the mandate of the code is that it has to be furnished within 24 hours. If it is not furnished within 24 hours, does it have any legal standing, my lords? That is the question I'd like to ask them, because once that period of limitation lapses, the notice itself or any document ceases to be alive in the eyes of law, becomes non-est in the eyes of law. It does not matter if the format 18 was served to us in 2021 or in November or 30 years later, 20 years later, it does not. Once it crosses the 24 hours threshold, it ceases to be alive in the eyes of law. It becomes non-est in the eyes of law. And once that format 18 becomes non-est in the eyes of law, lords, then the 45 days notice period does not even come into the picture. Does not even come into the picture. Their temporary disconnection, according to their own affidavit, was done in August of 20. According to their own affidavit, the format 18 was served much later, 15 months later. Well, it's 15 months and 24 hours, there is a huge gap. Therefore, that notice itself is non-est in the eyes of law, and therefore the notice period of 45 days cannot possibly come into the picture. Therefore, my lords, through that submission, I'd like to impress upon this honorable court that that mandatory provision has also not been complied with. That the dates are also duly recorded in the impugned judgment. Now at 111. Now proceeding ahead, these are the admitted positions of non-compliance of mandatory provisions. Now, as far as the service of notice is concerned, your lordships have rightly noted, my lord. Your lordships have rightly noted that section 56(1) of the Electricity Act stipulates 15 clear days. The legislature was very particular in mentioning the words clear days. It did not say any notice. It did not say any notice. It said 15 clear days, my lord. And what does their purported notice say? Even if we assume that the bill is a notice in itself, what does it say? It can be disconnected at any point in time. It says it can be disconnected at any point in time. Not only are they playing fraud with the consumers, they're going against the provisions of the Electricity Act itself. Any days. And furthermore, your lordships have also rightly noted that, my lords, once the 15 days is not exercised, that notice lapses, and once a fresh one is issued, that will come into operation. And the notice issued, the bill issued in August, before expiry of those 15 days, they have admittedly disconnected, my lords. Therefore, that also is a very valid reason to deem and to declare that the disconnection was illegal. That is the third point, my lords. that no notice has been served. And as far as plus the judgment is concerned, I will not go through them for the sake of brevity and to save your lordship's precious time a lot, but I have judgments, I'll furnish them a lot. Here, the courts have held that section 24 of the earlier act is paramateria to section 56, because 56 flows from section 24.
The Rajasthan High Court.
Well, I have another judgment, a division bench from Patna High Court, that also lays down the same principle, that it is paramateria and that separate notice has to be served, because the ratio behind this is that the notice will only come into play when the consumer neglects to pay. That is the language of the act. When the consumer neglects to pay by the due date. Before the due date, there is no question of neglect on the part of the consumer. Therefore, in the bill, when there is a due date given, how can that also serve as a bill, my lord? Because a question of neglect could not have possibly arisen before the due date. And that is also noted in Prem Codex, my lord. Prem Codex that we have cited. I will just furnish copies, my lords, and my lords, I'd also like to furnish.
Prem Codex is for 56(1). For 56(1).
I'd like to furnish copies of
Yes, I have 56(1). No,
earlier.
My lord, if you're relying on Prem Codex, my lord may just refer to para
But
25.
I'd like to finish my submission and then they may, if at all. The first judgment that I'd like to refer to is, I'd like to first refer to the act itself, the old act, my lords. I've given a copy, just reproduce section 24. Your lordship will notice, I will not read the entire thing for the sake of saving precious judicial time. Your lordship will notice that the language is absolutely same with 56(1). The only difference is that the period has been extended from 7 days to 15 days in the new act, which also goes to show that the opportunity to a consumer to remedy their defect has been increased, thereby giving them more opportunity, my lord. Now, the first judgment that I'd like to rely upon is the Hasina Begum versus Chairman Chennai EDC, my lord. Your lordships have it, my lords. Here at page number 8, page number 8. Page number 8.
Hasina Begum.
Yes, my lord. Page number 8, paragraph number 7.1. Prior to the coming into force of the Electricity Act 2003, the Indian Electricity Act 1910 governed the law pertaining to the use and supply of electricity in India. Section 24, so and so, as follows. I'll read through in the next page. The next page, right after the italicized portion is over. Second paragraph, the Standing Committee of Energy. Your lordships have it. The Standing Committee of Energy, in its report dated so and so 2002, submitted to the 13th Lok Sabha, opined that section 56 of the 2003 Act is based on section 24 of the 1910 Act. And the last paragraph, my lords, of the extracted portion, it would thus be clear that the right to recover is one part of it, and the right to discontinue supply, so and so neglect is another part of it. So here, it has been amply held that it is parameter. Section 56 is in fact based on section 24. The reason why I am relying upon this again and again, is that when an act is succeeded by a subsequent act, the ratio does not go away unless there has been material difference, unless there has been material change. For example, there is IPC. IPC is sought to be changed from July. Certain the provisions which have remained same, just because the section number has changed from IPC to the new act, does it mean that the ratio laid down by the Supreme Court would cease to operate in the new act? Absolutely not. Because the ratio behind remains the same, so long as the spirit and the object of the provision remains. And here, section 24 and section 56 are absolutely identical, save the 7 days part. Now, the second judgment, the IVO pharmaceuticals.
These are Supreme Court judgment.
I know.
These are Supreme Court judgment.
I'd like to address this honorable court. The second judgment, IVO pharmaceuticals versus Bihar State Electricity Board.
This is from Patna, Mr.
Yes, madam.
Mr. Sharma, this is from Patna. Division Bench. Yes.
At it's page number 2. Here, a judgment has been cited wherein the concept of the requirement of the mandatory days has been dealt with. Number 6, paragraph number 6, your lordships have it, Rajasthan State Electricity Board. So the bill was given to the servant of the consumer. It was not delivered to the consumer personally, nor it was posted on his residential building at the address given in his application, nor it was sent by registered post. It was held by a learned single judge of the Rajasthan High Court that when these three things are not complied, and the time for payment given in the notice was only 2 days. Here, only 2 days. And not 7 days, then it should be presumed that the disconnection was made without due notice, and therefore the disconnection was illegal. Here at least 2 days was given in this case. But in our case, my lord, the notice says at any time. May be disconnected at any time. Now, at page number 5, paragraph number 16, their contention has been dealt with here, where they say that the bill can contain the notice. That contention has been dealt with.
Para 6.
Para 16, page number 5. A subsidiary question arises for consideration as to whether the notice in the instant case can be deemed to be notice of disconnection, assuming a bill cum notice is permissible. Assuming. In other words, whether notice in small prints on the reverse of the bill can be said to be sufficient notice of disconnection. Is the consumer expected to look to the contents on the back of the bill, which contains 3 paragraphs, and in para 2 thereof is the notice. Here also same a lot fine prints they have mentioned, it's included in the bill. Let us see the finding at page number 7. Page number 7, paragraph number 24. I am accordingly constrained to hold that the impugned action of the board was illegal, being in contravention of section 24(1) of the Indian Electricity Act 1910, as also clause 5B of so-and-so agreement. I further hold that notice contained in para 2 on the reverse of the electric bill cannot be considered to be sufficient notice in the facts and circumstances of the case. Now, this judgment was rendered by a division bench. The second judge, the Chief Justice of the Honorable Patna High Court, his lordship has also given his opinion. 3rd paragraph from there, I'd like to read. K.S. Paripurnan, CJ. I agree with my learned brother Sahai J. that the impugned action of the board was illegal. In view of the importance of the question involved for consideration in this case, I desire to express my opinion independently. It appears to me that it is possible to reach the said conclusion on the ground that there has been no proper or valid notice in writing before the electricity supply of the petitioners was cut off or disconnected. It is true that Annexure 3 electric bill for so-and-so was served in March so-and-so for a sum of 72,000. I will proceed on the basis that the petitioners did not pay the bill as per the demand. There was default. Section 24(1) of the Indian Electricity Act permits the board to cut off the supply after giving not less than 7 days clear notice. According to counsel, such a notice was served on the petitioners. The plea is that the bill itself was noticed. This is the plea, my lord. Now, paragraph number 26, what does it say? For the purpose of this case, I will assume that it is possible to have a composite document reflecting the bill and also a notice of disconnection or cutting off the supply under Section 24 of the Indian Electricity Act. The question is whether Annexure 3 bill, which is said to be such a composite document, satisfies the requirements of law. In my opinion, it does not. Next paragraph, para 28, this is the last that I'll be citing, Mullah. And even assuming that a composite document will serve the plurality of purposes, one as a bill and another as notice under section so-and-so, I am of the view that Annexure 3 herein is not a proper or valid notice as contemplated by the Indian Electricity Act. The bill is not one signed by the customer. The plea is that Annexure 3 bill on the reverse side contains so-and-so. So here it is held, my lord. I have given two judgments of two different high courts where they have consistently held that the notice itself cannot be part of the bill because it has to come only after the consumer neglects in paying their dues, which in this case, no such opportunity was granted. Now, these are the illegalities that have been committed prior, and also the lack of 15 clear days. That also is very pertinent as duly noted by Lordship. But again, apart from this, there is certain point that I'd like to apprise the Lordship regarding the non-payment of bill. Your Lordship may kindly appreciate that a disconnection was effected during peak Corona time. Peak Corona time, where they expected us to pay the bill. Peak Corona time, they disconnect our connection. And then even after that, to avoid litigation, we pay the amount that they charged from us, rupees 600. They themselves collected from us. And then now they say that, no, this is for some other purpose. It's a mockery of the entire procedure. And next, your lordships have also duly taken note of the fact that even if it is assumed that the notice is valid, then why were they continuously issuing day after day, month after month, cycle after cycle, cycle after cycle? It is just for general alarm. It cannot, under any circumstance, be construed to be a valid notice, my lord. And the honorable courts have consistently held that when there is no valid notice, then the disconnection has to be deemed illegal. And that is precisely our contention before this honorable court and prayer of this honorable court. And the third point, my lord, where they say that the 600 rupees was disconnection, I'd like to take your lordship through the appendix. Appendix number 4 contains the fees that are to be given. Appendix number 4 of the said code, my lord. Disconnection and reconnection.
Tariff regulation or?
Of the regulation, right? Appendix 4, general and miscellaneous charges.
Page 230.
Appendix 4.
Before annexes. After annexes.
And after annexes.
After the formats.
After the formats, my lord.
Round about page 230.
On the soft copy, it's towards the end of the document. The last.
Appendix, yes.
Yes, appendix 4.
Yes.
They say that rupees 600 for disconnection. Your lordship may kindly come to point number 6, disconnection and reconnection. These are the charges. Nowhere, my lord, nowhere is the figure 600. Nowhere is the figure 600, my lord. These are just oral submissions without any affidavit support. These are just submissions, just like how they said that format 20 is not applicable to us, just like how they said that there is no agreement between us and the distribution company. And the appendix also itself is clear. There's no 600 rupees more in the entire appendix. And the only argument that they've raised before this honorable court to justify their illegal action is that they say that we've admitted that we were aware that we had not paid the fees. First of all, my lords, peak Corona period. We could not have even if we wanted to. But keeping that aside, just because we are aware, does it mean that they can supplant their will over the mandate of the act? Does it mean that they can bypass the notice just because we know? Like on the first date itself, I had brought in a parallel of Negotiable Instruments Act, my lord. There, the drawer gives a check which gets dishonored. Does it mean that the drawee can bypass the notice of 15 days and file a 138 case, my lord? Absolutely not. That is the mandate of the act. Just because we were aware.
NIT case, there is a judgment of the honorable appellate court. I still remember I argued in a matter.
My lords.
The honorable court considered that aspect that this period was not over. 15 days.
Yes, my lord. Absolutely, precisely, my lord. When it was not over.
A discretion charge to MLC.
And without that obligation of this period, there could not have been finding of any such case under the NIT.
My lord.
Judgment of the apex.
Yes, and disconnection, my lord, 8.2. 8.1, 8.2 is for temporary disconnection, 8.1 is disconnection. That provision itself states that disconnection has to be done under Appendix 4. And Appendix 4, the fees have to be done under Appendix 4. And Appendix 4, the fees are given, there's no mention of ₹600. Again, my lords, just figures out of thin air. Now, these are the agreements, and like I said, my lords, for as far as their contention is concerned regarding bypassing of the notice, that is absolutely impermissible. And they're saying they bring in the question of us challenging the bills. But at no point in time have we challenged the bills. At no point in time have we challenged the bill. There's no question of us approaching the ombudsman. This is not a question of the quantum that appears in the bill. It's about the illegal activity of disconnecting. Now, the last point that I'd like to apprise your honorable lordships about concerning the compensation that we've claimed. But again, the amount that we've claimed, that has not been plucked from thin air. That amount, we have duly annexed the tenancy agreement, the rent agreement that we were being paid prior to the disconnection. The property, my lords, the property in question is in GS Road, and it's a commercial property on the main road. And we have annexed duly executed tenancy agreements wherein the amount is 30,000. It is not a whimsical figure that we've given out of thin air or out of our own imagination. These are actual loss of profit, actual loss of business that we have incurred because of them. And your lordships will also recall that on the very first day, they were given liberty. This honorable court was pleased to record in its order that pendency of this writ petition would not bar the respondents to restore our electricity connection. That means they were at liberty. They chose not to do it. Since they chose not to restore our electricity connection, now they have to pay for it, months. Because at that point in time, liberty was granted to them. Had they reconnected our electricity back then, when the honorable court granted them liberty, then the question of compensation would not have arisen. But they did not do that. Since they did not do that, at this juncture, they cannot have any other recourse or remedy, and they will have to pay the compensation, my lord. And we have not asked for any extravagant or exorbitant amount. We have asked for what we have actually incurred. And this illegality, another argument was that the final argument was that this illegality, if it is not nipped at the bud, then this will perpetuate. And again, the question of us applying for fresh connection. Again, this case is not regarding the consumer number. They're saying that meter has been removed, so we cannot allow the previous meter number. We're not. This does not concern that. Our main contention before this honorable court is that the disconnection is illegal. Why should we apply for fresh connection? Because since it is illegal, then they should reconnect it. Why should we apply for fresh connection, my lord? And I need not mention, my lords, the ancillary charges and expenses that come along with fresh connection. Our only contention before this honorable, it does not concern meter, it does not concern anything else. Just that your lordships may kindly declare this disconnection as illegal, and the consequential benefits such as reconnection and compensation and loss of business and loss of profit will automatically follow your lordships.
And finally, your lordship, a single judge has not noticed.
My lord, just two things. My lord, with this regard, 700 rupees, there's a notification I'm going to share with my lord that the amount has been changed. Those books are old books, the appendixes have been changed. And second thing, my lord, format 20, at the bottom, it has been particularly says that if any amount is due. So at format 18 says no further notice. So there is no link between both.
And let's the last one.
This IVO pharmaceutical, the facts of the case is that they had paid the electricity bill. Where, my lord, the cases comes before, my lord, where they have paid the electricity bill. When they paid the electricity bill, there was something disturbed with the bill. The facts very clearly says this. According to was raised on minimum guarantee in respect of industrial connection, the factory remained without supply for more than 16 and hence the demand of annual minimum guarantee was illegal. They had paid the bill. I'll give the amendment copy.
Give the date also. Give the date when, from which it has.
Yes, ma'am.
Right, councils are respondents. Yeah, petition. Arguments are heard, order is the.
Much obliged, ma'am.
Grateful.